ಹಲೋ ಮೇಡಮ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್. ಕ್ಯಾಮ್ರಾ ಸ್ವಲ್ಪ ಆನ್ ಮಾಡಿ ಮೇಡಮ್, ಫೋಕಸ್ ಚೆಕ್ ಮಾಡೋಣ. ಸುರೇಶ್ ಮಾತಾಡೋದು.
ನಿಮಿಷ. ಹೇಳಿ ಸರ್.
ಹಾ ಮೇಡಮ್, ಸ್ವಲ್ಪ ಕ್ಯಾಮ್ರಾ ಆನ್ ಮಾಡಿ ಮೇಡಮ್.
ಕ್ಯಾಮ್ರಾ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ ನಿಮ್ಮ ಕಂಪ್ಯೂಟರ್ ಅವರು ಬಂದು.
ಎಸ್ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್. ಬಂದೆ ಮೇಡಮ್, ಅಲ್ಲೇ ಒಂದು ನಿಮಿಷ ಬಂದೆ ಮೇಡಮ್.
ಎದುರುಗಡೆ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀನಿ.
ಮಾಡಿದ್ರೆ ಕೊಡ್ತಾರೆ. 24 ಸೀರಿಯಲ್ ನಂಬರ್ 20. ಇದು MFIs ಆಫ್ ದ ಇಯರ್. ಸೂಟ್ ಯಾವ ಇಯರ್ ಎಲ್ಲ ಕೇಳ್ತಾರೆ. ಒಂದೊಂದ್ಸರಿ ಕೇಳ್ಬಿಟ್ಟು ಆಫ್ ವಾಟ್ ಇಯರ್. ಏನೋ
Court officer.
ಸರ್ ಹೇಳಿ. ಏನಿದೆ? ಕೇಳುತ್ತಲ್ಲ. ಒಂದು ಇನ್ ಚೇಂಬರ್ ಮ್ಯಾಟ್ರ್ ಇದೆ, ಅದು ಕೊಟ್ಬಿಡಮ್ಮ ಚೇಂಬರ್ಗೆ. ಲಾಸ್ಟ್ ಮ್ಯಾಟ್ರ್ 811/24.
Actually, the mother was come from Gwalior for the Independence Day week, the Lordship had passed the orders in chambers. Because the order copy is not received, she refused to come.
Why the order copies?
So may I take some request? No, now that order will have to be modified for us, because he's been paying everything in terms of the Lordship's order, even to the extracurricular activities and the car EMI, 1 lakh rupees a month.
No, please give the number. It must have been like long back, nothing, no order is pending till now. No, but it's soon on the 15th of July is.
He spoke with one that all has been now paid, because she's not come for the case, another arrangement that she made. For being spoken with the like.
No, just see why July order is not uploaded till now. Because no cases or no, nothing for correction is pending as of now.
So declared in your Lordship's chamber.
No, but the order is like, I must have dictated, no, that time?
Yes.
Yes.
Lordship kindly, brother, serial number 28, that in fact I have approached this honorable court, allowed me to, they have already demolished the entire portion. 2 weeks time, I can give you. 28.
2 weeks, yes.
Not in this matter.
My modification application. Bring to your lordship, this one message that you sent 2 days back, which is very, very demeaning to her. Not sure if it is not yet passed, then I'll file it in the registry.
File it in the registry, not at pass.
No, okay, I will serve it on them and then file it. Great, because I don't want to move and for it to be listed again to waste time. Great.
Yes. Which year is that? Which year is MFA? We'll see, because there are some more matters which are pending for admission itself.
22nd.
My lord, 24 matter.
Take it.
Maintenance, madam, or interim models, they have been granted subject to condition of or in 2 lakhs. Once we deposited belatedly, already more time is over for what stay of execution.
Amount is deposited. You are appearing for whom?
I am appearing for the order of the husband.
Conditional order is passed
Petition order was passed. my lord.
tomorrow. Yes.
My lord, I got the title by way of gift deed, and the respondents have created the documents and they are trying to trespass, my lord. So kindly,
Which year is that?
24, my lord.
Yes, day after tomorrow.
Obliged.
Lordships,
No, it will again, notice will be ordered, new matter, new writ petition. Which year is that? No, you expect your 24 matter to be heard right now and orders also to be passed. Take it after 4 days. Yes.
Serial.
Out of the list.
My lordship,
Any
serial number
memos are
29,
there,
my
then
lords.
you may- Yes.
my lords, serial number 29, my lords.
Hmm.
My lords, it's for withdrawal, my
Then
lords.
call the list by
Page
page wise, then you can mention. Yes, one.
One kind submission, my lord. In this matter, that was last listed on 14 for maintainability of appeal. That lordship disposed of the matter on the ground that appeal is not maintainable. Actually, not true, my lord. It is very much maintainable. It is not a commercial appeal. That property of the
What, and in which court you have filed that?
this court, only.
Court.
Section 34 before the regular court only.
Commercial court, not commercial.
Not
court.
commercial court. Land losers matter.
Take that. Yes.
My lord.
And I think- The evidence of 22, the laws had ordered for the. The matter may currently go to any date than next week.
Next week.
My lord,
Yes.
WP of the 2023, my lord, for preliminary hearing, my lord, your lordship may have it on any date, my lord.
We'll see.
Your lordship, serial number 15.
They'll call page wise, they'll call.
Page wise adjournment, page 1, serial number 1, page 2, serial number 2, page 3, serial number 3, page 4, serial number 4 to 7, page 5.
Serial number 7,
Yes.
I want a week's accommodation.
7.
No, it can't be. Yes, next.
Serial number 6. Well, my lord.
Huh?
I'm not keeping well, my lord.
But every time on that ground, the matters can't be adjourned, Mr. Umesh.
My lord, next week I'll appear, my lord.
2018 matter. Have you
Yes,
informed the
my
other
lord.
side?
No, my lord, respondent has not appeared, my lord.
Post this matter next week, no further adjournments will be granted on
Problem.
whatsoever ground.
Problem.
Yes.
Serial number 6, my lord, 6.
Serial
So
number,
this 6,
yes.
this original petition, MMC petition has already disposed, my lord. So with regard to that,
When was it
appeal is pending.
disposed?
Was disposed on 8/11/2022, my lord.
It is submitted that it's MC.
So unfortunately, I am not filed NOC in this case, my lord. NOC on behalf of the petitioner. But entire writ papers are forwarded to me. So this is the technical issue. my lord.
Anyhow, the MC itself is disposed of, take the date on so and so, in that view of the matter, this petition becomes infructuous, accordingly dismissed as infructuous. Yes,
Page number 5.
yes.
Serial number
10 for withdrawal because of instructions.
See,
5
take
to
that.
11.
A memo is filed to withdraw the writ petition accordingly. Dismissed as withdrawn. Yes, 11.
Then
Who moved the slip?
your part.
Pose this matter after 2 weeks. In spite of moving a memo, again sought for adjournment today. Pose this matter after 2 weeks. Yes.
Page number 6, serial number 12, page number 7, 13, 14. Page number 8, serial number 15,
Your lordship,
16.
serial number 15. Your lordship, a short accommodation because the interim order is in Kannada, your lordship.
So we'll furnish a copy, I mean, translated copy.
Notices are not served so far.
No, Your Lord.
15, it is submitted that for filing a translated
Date may be
copy.
fixed, Your Lord.
Post this matter, when?
Your Lord, a week.
Next week? Yes,
Page number 9, serial number 17 to 21.
Serial number 17.
yes.
Tomorrow.
Have you informed the petitioner?
If appellant may be posted tomorrow.
Tomorrow at the request of Land Counsel for the respondent? Yes.
Material number 20, my lord. Still representing the respondent is added. I informed the other side also. It may kindly post it next week.
Yes, next week, next Thursday,
Please. Public.
at the request of counsel for the respondent. Yes, next.
Page number 10, serial number 22 to 25. Page 11, 26. Page 12, 27 to 29. Page 13.
My lords, page number, serial number 29, my lords.
Hmm.
My lords, memo has been moved to withdraw the petition, my lords.
Yes, a memo is filed seeking to withdraw the RPFC accordingly. The same is taken on record. Dismissed as withdrawn. Yes, next.
Page number
DP
30,
obliged, my lords.
serial number 30 to 33. Page number 14, 34 to 38. Page 15, 39 to 40. Page 16, 41 to 43. Page 17, 44. Page 1,
All the list.
MD Raghunath for appellant, serial number 1.
I appear for the appellant, my lord.
Sarvana S.
That happening continuously, somebody is talking. Tell me. No. That number they have mentioned, no, that July, why that order copy, Anita, the July order copy, why it is not uploaded today, it's a very strange thing. Just right now find out from Suvarna, take the number. Yes.
Please, ma'am. I appear for the appellant. This is an appeal, my lords, wherein the Honorable Trial Court had dismissed my application IA number 1 under Order 39-1 and 2 on 25/7/2023, my lords. The crux of the matter is this, my lords. The appellant had filed a suit for partition and possession over the properties, especially for property bearing number 302 and 303 itself, my lords. Upon the respondent coming into the picture, my lords, had filed their objections, and it was seen, my lords, that the contention was raised specifically by the respondent, stating that the property was not the it was not a self-acquired property of K. Moses itself. K. Moses, in fact, is a reverend father. His children, my lords, is the appellant as well as the respondent number 1, my lords, apart from the other set of respondents. My humble submission to this honorable court is this. Apart from the respondent number 1, there are other set of respondents, my lords, and all of them have actually filed a memo before the honorable trial court stating and admitting that they have no problem in sharing with respect to the property itself, with respect to the partition, my lords, which I may bring to my lord's attention to the memo filed before this honorable court on 12/8/2024.
What is the injunction you sought?
Please, my lords. The injunction, my lords, was that the respondent number 1 has in fact demolished. In fact, during the course of the application, my lord, the application was filed for preventing him from any having any further construction or demolishing the building, my lord. But in the course of the hearing itself, the demolishing was done by the respondent number 1. Hence, the honorable trial court came to certain conclusions, my lord, wherein, if I may bring to my lord's attention.
No, now what remains in that? Now your IA is not to demolish, he has demolished.
That's true, my lord. That was also, it was not only, my lords, with respect
What is
to
the other relief?
the other relief, my lords, is not to put up any further construction with respect to the property itself, my lord. If I may
Come
bring
to
to
the
my
order,
lord's,
please come to the order straight away.
please, my lord. If I may bring to my lord's attention to ink page number 17, paragraph number 10, my lords. It says, 5th line from the top, my lords, it says the 7th defendant, who's the respondent number 1, has not only produced the allotment letter, but also produced the trust deed.
He is a 7th defendant.
Yes, yes.
has also produced the trust deed.
What is the relation between the plaintiff and the seven defendant?
Siblings, my lord, they are the brothers.
So,
And in fact, the father who's.
no, how
Reverend
many,
K. Morses-
let's please look at the, come to the cause right?
Please, madam. Yes, my lord.
Appellant is a brother.
Yes, my lord.
The respondent, one is sister.
The brother,
and
madam.
two. Mrs. K.
Respondent number one is the
Shantama,
brother.
wife.
Mother.
Mother, apologies, mother.
First is mother, second is
Second is the daughter, sister, basically.
sister, third,
Third is again a sister, my lord.
fourth.
Fourth is a sister, fifth is a sister,
Hmm.
sixth is a sister,
Hmm.
seventh is the brother, my lord. And eighth is the sister,
Yes.
please. It's between the family. My humble submission is this, my lord. The father of the respondents as well as the appellant was the erstwhile owner of the property bearing number 302 and 303. The contention raised by the respondent is that, my lords, that there exists a trust deed. By virtue of the trust deed, the property is not a self-acquired property, but the property belongs to a church.
What is the role of the seventh defendant in the trust?
Yes, my lord. I'll come to that aspect. In fact, if I may bring to my lord's attention to the memo filed by me on the 12th of August 2024, in page number 76, my lord. That is the trust deed. Trust deed, my lords, was executed and created, my lords, on 12/1/2021. In page number 76, my lords.
Yes.
Please. This is the trust created on the 12/1/2021. What is very important, my lords, is the dates. The reason why I'm stressing before this honorable court for the dates is because in their own written statement, they admit at paragraph number 4 at in page number 43, my lords, in page number 28, my lords, paragraph number 6, apologies. That is the written statement filed by the respondent itself, stating that the contents made in para 4 is true that late Reverend K. Moses put up a small prayer hall in the year 1946.
Yes.
During the British regime, during which time the land belonged to the British until the independence of India in the year 1947, and later the land belonged to Indian Air Force. Until this land were around 1,000 residents were living and was handed over to the government of Karnataka and was notified as slum area under the Karnataka Slum Development Board on 28/6/2005. My lord, it is crystal clear that since the year 1946, the father of the appellant as well as the respondents have been in possession of the property, was the owner of the property. In fact, when the respondent had produced the trust deed, which is created only on the 12th of January 2021, which, my lords, is after the death of the father, Reverend K. Moses, has, my lords, malifiedly not mentioned this scheduled
So,
property.
apart from this, what is your case that to say that it's a joint family property?
I
What did
understand.
you?
If I may bring to my lord's aspect only one aspect of the trust deed. In fact, of course, it's
No,
on
let's not look into the trust deed, which is subsequent to your father's death. Please, what is the other material to show that it's a joint family property?
Please, my lords, if I may bring to my lord's attention to the affidavit itself at ink page numbers 19, my lords. This is the affidavit produced along with the memo. This is the translated copy, my lords.
What is the nature of the property?
This is actually it's an immovable property based, or it was there only for the purpose of the
Is it a
church.
church or not?
It's a church.
No, you will partition the church now.
No, my lord. In fact, what has happened is there are two properties adjoining to each other. One is the church at 302 And 303 has a charitable institution for the educational purposes, my lord. It's like a prayer hall.
No,
Please.
if it's a charitable institution, it must have been, it must not, I don't think it can be a property, individual's property. No, where is the question of it is a charitable trust, then once it is a trust property,
Please.
where is the question of you people partitioning it?
That's where I had to come before this honorable court by stating, my lords, or by submitting that it is not a trust for property, my lords. Because what happens, of course, this honorable court
No,
is very
as of
aware.
now, that property, if there is a church in that,
Please, my lords.
any that charitable institution, whatever it is there, whatever name or nomenclature you give it to that. Now, at this point of time, where is the urgency for any injunction? Whatever it is running, let it run.
Let it be so, my lord.
Hmm.
The only problem is my humble submission that if there comes up with any construction, my lords,
What will happen?
my lords, the construction will lead to changes in the nature of the property.
What construction they are making according to
Maybe
you?
a construction, my lords, with respect to,
If I be permitted to say, Lord, now there is no construction, it is a vacant site. They are trying to put up construction and they are, it's actually, it was a prayer hall. Now they wanted
Why
to.
was it demolished?
They demolished it, Mila. It is not me. I wanted it to be intact, kept in intact.
Oh, they will again construct it and keep it
My
intact.
lord, then my lord,
They will
what?
not claim any equities in the event, if some order is passed. These kind of, yes, what do you say?
Yeah. I may make a submission. This is only a dispute where the brother want to come into the trust. He is creating lots of problems. It's a charitable trust, it's a for the public, general public at large. And for the poor people, they are constructing a center for learning. And this was for the public, it's not for the individual purpose. And what there the documents which has been produced, they only have produced that it's a hak patra which has been given by the slum board. And all BBMP people have given us the khata. And we have taken permission from BBMP to construct the building, and half the portion has been complete, almost the pillar has come up.
It's a church.
It's a church for the public. It's not for the individual thing. And anybody, the trust is died, somebody else will run the trust. It's not for the individual purpose which we are constructing. It's for the general public, for a betterment of the public.
Yes, please come.
may I make a
Yes,
humble
sure.
submission, my lords. If
Yes.
I may be permitted for a minute's time.
Yes.
If that is the case, my lords, the trust deed itself is void under the law itself.
That
Because
has to challenge
under
it.
section 3 of the Trust Act, a trust, which means, my lord, there should be a transfer of an ownership of the immovable property itself. Here, there is neither the schedule showcasing that there exists any kind of an immovable property, 1. 2, on what basis does the respondent have a right over the property?
So is it your case that in your property you constructed a church? Your father has constructed a church?
Yes, my
No,
lord.
what, no, it is, it has become a public more, it is every, the general public have unrestricted access to that place.
My lords, the intention,
Once they have an unrestricted access to a particular place, a particular religious institution, what is the right of what is your right? Everything has to be decided. It is not your case that you have been enjoying independent, you have an independent right in that, no.
likewise,
Everybody
my
is-
lords, even they do not have an independent right.
It is
Why?
not about you and them. It is not about you and them. No, there was no, they are constructing a church, let the church be constructed, because as it was there, according to you admittedly. No, once they say that it's a joint family property and something has to be done, ultimately court has to come to such conclusion, then an order will be passed. Because it is not your case that you're in occupation of the property.
I agree, my lords.
Yes.
My
Point
only humble
possession.
submission is that lead to wastage of lot of resources, my lord.
Whose
Lot of
resources?
resources would be wasted.
You say that there is no trust, then why are you bothered about the resources?
In fact, the resources is, if there is any construction done in the scheduled premises, then that would lead to further complications and wastage of resources, my lords.
Whose
Henceforth, at a
resources?
later point of time.
Whose resources?
As of now,
Whose resources?
government land itself. my lord.
Government
Go- I'm sorry, government resources. In fact, if.
Why
if-
government is constructing?
No, they are taken grant from the government to put up construction. Lord, it's a private property.
These kind of disputes, courts are not for settling this.
I understand, my lords, but in fact, what they have to take into consideration is, if there is any such construction.
Please come to your plate.
Please, ma'am.
What I'm indicating is, if on the face of it, if the court finds that this is a kind of, without any basis, these applications are filed, then we have to pass some other order. Please come to the plate.
Please, my lords.
Yes.
Plain.
page number?
It is at in page number 21, my lords.
What is allotment?
My lords, what the government has given to the, any individual.
What purpose? There will be a purpose for every allotment.
I agree, my lord. In
So
this
for
scenario,
for construction of a church,
please, my lord.
for a religious institution, government has ordered. According to you, it will become your personal property.
My lords, my humble submission is this. Since 1946, the Father Reverend K. Moses has been in possession of the properties. And apart from being in the possession of the properties, he has issued numerous letters, my lord, stating that the church, the government may permit him to construct further set of buildings itself in the scheduled premises. That could constitute a prayer hall. It could constitute a building for the helping the needy children with respect to education and that sort.
Now you will partition the properties, all your sisters and brothers will partition the church.
My lord,
Will partition the charitable, whatever is
humble
running.
submission is this. My only humble submission. If that was the case, my lord, the entire scenario of the respondent is that there existed no such prayer hall at that point of time because he had already demolished the building. If that is the case, let the same status quo be itself, my lords. Anywhere there exists no such building in the scheduled premises.
The malified intention of the plaintiff itself is very clear from this submission.
My lords, if I may bring to my lord's attention again to the memo filed on 12/8/2024, wherein the respondent number 7's wife itself has filed a police complaint, my lord, stating that the property was belonging to the father-in-law and subsequently he has usurped the
Neither
right.
he nor you cannot claim the property to be of your father or father-in-law.
My lords, that I humbly bow down to this honor. That is with respect to certain aspects to be considered by the honorable trial court with respect to after taking into consideration the documentary evidence, my lords.
May I make one submission?
Yes.
I'm sorry. Lord, as my lord suggested, let the trial court decide as to whether we are entitled to share in the property or not. The only point now is, my lord, 1946, father had entered into the property.
If the property is kept open and there is a prayer hall in that, what is that you're losing?
There was a, my lord, what prevents him?
Do not want the people
No, no, no,
not to go to the church and have the prayers.
I am not having
So
such an
you are
intention.
seeking an injunction from the general public from going to the place and having rendering their prayers.
My lord, had I had such an intention, I wouldn't have filed this suit from stopping him to demolish the prayer hall. Was the prayer hall in existence, my lord, I wouldn't have filed the suit. He started demolishing the prayer hall, only then I had to knock the doors of the trial court, please.
What is existing from time immemorial? If it has to be restored, let it be
My
restored.
lord, may I make one more submission?
Yes.
A trust is created excluding the family members.
That's a different aspect that you have to work out your remedies where it is, where you have to, not before this court, not in an injunction petition, not in a suit. In a suit for partition, court will not decide that whether the trust deed is right or wrong.
But I have to knock the doors of the court only to seek remedy, please. my lord.
No, you have a remedy for that also, for a trust deed. Under which law it is registered, what is your right, that will be decided. Agreed with the orders passed in I number 1 in I number 1 in OS number 26660 for 2022 dated 25th July 2023. Whereby the trial court had dismissed an application filed by the plaintiff seeking injunction. The plaintiff is before this court. The appellant herein had filed a suit, voice number 26660 of 2022, seeking partition. The parties are the appellant is a brother, and the first respondent is a mother, and respondents 2 to 6 are the sisters, and the 7th respondent is the brother.
8 also is the sister.
Huh?
2 to 6 and 8 are sisters. 7 is the brother.
8 are sisters, and 7 is a brother who is the contesting respondent, defendant. In the IA that is filed seeking interim injunction, it is stated that The seventh defendant, after entering appearance, has not filed any written statement. He has taken law into his own hands and started demolishing the suit scheduled property, which he is not entitled to do so. Pending the suit, the seventh defendant cannot be allowed to cause damage or allowed to demolish any portion of the property. It is stated that they have made out a prima facie case. Balance of convenience is in the favor of the plaintiff, and greater hardship will be caused if this application is not allowed. Hence, they sought for an injunction restraining the seventh defendant from demolishing any portion of the suit scheduled property or putting up any construction till the disposal of the suit. In the plaint, it is stated that the father of the plaintiff, that is K. Moses, acquired the immovable property bearing numbers 302, 303 near Bethel Church, Siddharthanagar, Ward number 16, Jalahalli West, Bangalore, under the allotment letter issued by BBMP dated 25/3/2017, which property is 2017. In the property number 302, the church is constructed, and in property number 33, a charitable society, Bethel Student Center Charitable Society, is formed and is being run, which was created and started by Reverend K. Moses during his lifetime. According to him, according to the plaintiff, it was treated as a private property of Reverend K. Moses. In his lifetime, between 1946 to 1980, he put up construction of church, prayer hall, and abutted to the prayer hall residential premises, and the same was assessed by BBMP, and BBMP is collecting taxes. His father is also a priest designated as Reverend Father K. Moses. He has continued the priesthood till his death, who died on 25/6/2010. The church which was built is known as CITM Bethel Telugu Church, and his personal properties were distributed during his lifetime, and he died intestate. And now they sought for partitioning of those properties between the family members. According to the plaintiff, he is enjoined possession of the property and has right over the same. He has been requesting the defendants to effect partition and put the plaintiff in physical possession of his undivided 1/9 share in the scheduled properties. And as the same was not done, he was constrained to file this suit. It is submitted that the defendants, except defendant number 7, all the defendants have filed their memo stating that they want the properties to be partitioned. The defendant number 7 had filed his returns, not, you said all the defendants have.
No, only it was defendant number 1, 4, 5, 6, and 8.
Right, that defendant number 1, 4, 5, 6,
and 8.
8 have filed the memo stating that they have no difficulty. The property has to be partitioned. A written statement is filed on behalf of defendants 2, 3, and 7. It is their case that the plaintiff, with malicious intentions and greed for personal gain for the said property, has filed the suit. It is a case that the plaintiff owns a musical school by name Bethel School of Music at number 296, 3rd class, 2nd stage, RMB Extension, Bangalore, running successfully for more than decades and has got sufficient income from it. And further, he owns a family trust by name KMS Bethel Trust, a personal family trust. and plaintiff forced their father to be the president of the trust in order to make personal gain for himself. Now he is trying to grab the part of the church property as well as the Bethel Student Center property. The plaintiff had never requested the defendants to put him in fiscal possession of the 1/9 share in the suit scheduled property. And also, and it is stated that there is no cause of action for the plaintiff to file the suit. The trial court, while dismissing the said application filed by the plaintiff, had observed that
Hello, sir. Jaiprakash Rao. Please unmute your.
the court observed that the trustee court has observed that during the course of arguments, the counsel for the seventh defendant produced documents in addition to photographs for having already demolished the entire building for reconstruction, pursuant to allotment of money by the department. The seventh defendant has not only produced the allotment letter, but also produced a trust deed to establish that the scheduled properties are being managed by the trust and not by the family of the plaintiff and defendants. All the encumbrance certificates, registration certificate, and form number 10 AC in respect to the suit scheduled property are all standing in the name of church and not in the name of family members of plaintiff and defendants. The trust deed indicate that both parties are being managed by the trust and not by the family of the plaintiff. And the photographs indicate that after demolishing the old building, pillars have been erected in the suit scheduled property by laying foundation. It appears that the plaintiff is sitting over the fence all these days and filed the suit for partition. The court has further observed that the documents on record prima facie reveal that the properties in question are allotted by the government for the church and not for the family of the plaintiff. Hence, the court felt that there is no prima facie case made out by the plaintiff. And at this stage to grant temporary injunction in favor of the plaintiff. The court further observed that the government of Karnataka, by the order dated 11/4/2023, allotted a sum of rupees 30 lakhs for the development of the church and the Bethel Student Center, and out of which rupees 15 lakhs has already been released by the Minority Welfare Development Department, Government of Karnataka. Therefore, if at this stage, if construction is stopped, it is the public at large who are the devotees of the church will be put to irreparable loss, hardship and injury. Equally, the students of the church will also put to hardship and injury. The court has further observed that prima facie the property is not allotted to the father of the plaintiff, and on the other hand, it is admittedly allotted to the church. Therefore, no prima facie case is made out. And the court has also observed that the plaintiff has not disputed the existence of church and the student center in the scheduled property. Accordingly, dismiss the petition. Aggrieved thereby, the appellant plaintiff is before this court. Learned counsel appearing for the plaintiff submits that the property, submits that the father of the plaintiff was allotted this land, the suit scheduled property, and from he has been in possession of the property. It is submitted that after the suit is filed, the defendant number 7 has demolished the church, and now he is proceeding with the construction. The trial court has failed to consider that if the church, if the nature of the suit scheduled property is changed, there will be wastage of the resources, as the government has granted, has given a grant for construction of the church. And further, all the majority of the family members have filed a memo stating that they also want the partition of the said property, and it is a self-acquired property of their father. He submits that the court had considered the trust deed, which is of the year 2021, and much after the death of the father. 2021, March of the death of the father, and have given certain findings as if certain findings and had dismissed the application for interim injunction. Then counsel submits that the seventh defendant, only with an intention to grab the joint family property, has come up with such a stand, and the court ought to have granted injunction. Anything else?
Just one more humble submission. Ma'am. In fact, it is not in accordance with the Trust Act as well, wherein the properties are not mentioned in the trust deed as well as.
Trust deed of which year?
Of 2021. Ma'am.
That's, yeah, because the court is not going into the trust deed.
I understand.
The trust deed, it is submitted that the trustee is not, that the trust is not established as per the provisions of the act. And further, the properties are not mentioned in the trust deed, and the court ought not to have taken into consideration the said trust deed, and ought not to have rejected the application filed by the plaintiff. Next paragraph. Then counsel appearing for the defendant submits that there is a church existing from times immemorial in the said place, and the government that it was always granted in favor of the trust for running a church, but it is never a property of their father. It is submitted that even the latest grant that is given for construction of the temple, for construction of the church, shows that the government if it is a private property of the father, the government would not have granted. It is submitted that the student center and the church, all these things reveal that the nature of the property right from several years is open for the public, and it has been used, and as per the entire land is used for the purpose and for the benefit of a particular class of people, He submits that the trial court had rightly considered all the aspects and all the material placed before the trial court and rightly rejected the application. Next paragraph. And it is submitted now, text para, same para, it is submitted that no grounds are made out seeking interference with the order of the trial court. Next, having heard the counsels on either side, peruse the material on record. The suit that is filed as a suit for partition. In the plaint itself, the plaintiff states that there is a church and there is a student center and some residential accommodation in that. According to him, though they have been running the same, but the said property that it is stated that Bethel Church is constructed in property number 303. The charitable society Bethel Students Center charitable society is formed and is being run, which was created and started by his father. However, it was treated as private property of Reverend K. Moses. Now, in the suit, the crux of the issue is whether the property is the personal property of the plaintiff's father, for which the plaintiff and other defendants are entitled for partition, or whether it is property belonging to the charitable institution. When it comes to the nature of the property and how it is utilized, there is no dispute on that. Those are the admitted facts. Now the plaintiff comes up with a plea that the plaintiff, the defendant number 7 had demolished it, and secondly, now that he is going to construct. When there is an existing church from a very long time, and the government has issued a grant for construction of a church, and the church. Now, why the construction has to be stalled and how the plaintiff is entitled for injunction in the considered opinion of this court. Absolutely. There is no prima facie case in favor of the plaintiff. That too when the property, which is open to the public from several years, where the people are offering their prayers. Now, in a tussle between the family members, for whatsoever reason, such activities cannot be, such construction cannot be stalled, which in the larger public interest is not correct. Now, once the construction is completed and subject to whatever the orders that are going to be passed after a full-fledged trial, the consequences will flow. The basic ingredients for grant of a conjunction, that is the prima facie case, balance of convenience, irreparable loss, or conspicuously absent in this case. And the trial court had rightly rejected the application, and this court finds no reasons to interfere.
The submission
Observe.
my lords may kindly observe that it does not affect in any way the merits of the matter.
Huh? All any of the observations made by this court while deciding this application shall not be construed as expression of this court, and the trial court shall decide the application on the merits of it.
And also one more humble submission. If the construction should only be restricted to the religious activities of the church, if I may humbly submit one.
That's beyond your
No, my lord,
application.
whether they construct anything or any other building apart from any regional activities.
No, already there is a grant. What is a grant? That is for construction of a church and for that student center. So why should there be another observation? Then in that case, no, let's not enlarge the scope of the petition. Now, if they are doing any construction contrary to the BBMP permission, you will approach the BBMP. BBMP will take care.
But again, that will also create a lot of burdens.
If any construction, one of the clauses, if any construction is made contrary to the license granted by the BBMP, it is always open to the plaintiff to approach BBMP.
Please, ma'am.
Yes.
Much obliged.
Cell number 2. Kumar and Bhatt for appellant. Yes, Murali.
This case.
What about the respondents?
Yes, Murali for respondent number 2.
MFA of 2012.
Yes. This is, my lord, a rejection of, my lord, order 1 rule 8.
Rejection of?
Order 1 rule 8 application along with 39(1) and 2. And, my lord, this is 92.
There is a stay in this.
Please, my lord.
There's a stay in this.
No.
Stay.
A stay, my lord, subject to sell of one property since the order granted. But, my lord, now, my lord, the respondent, what is concerned, my lord, the point is, my lord, in the custody of, my lord, in jail because of hopes and all these things. My respective submission before this honorable court that my application has been rejected on technical ground without verifying the documents. Therefore, this is fit case for setting aside the improved order, rejection order, and
We'll pass orders, we'll pass over and pass orders. Please inform the advocate.
have it tomorrow. Can have it tomorrow.
Why again tomorrow, 2012 matter? Whenever you can come, or you come afternoon. We will dispose it off. today. Yes.
Please.
But
Cell number 3. Cell number 3. Nehru P.
Yes. Where is the respondent?
Rajesh B. Shetty, Rakesh B. Shetty.
My lord, we have paid 2 lakhs on 15th of August. Money transferred. As per the earlier order that was
2
produced.
lakhs to the respondent by 19/8. Accordingly, the petitioner had transferred the sum of 2 lakhs on 15/8 to the respondent. Yes, Mr. Counsel.
We have received 2 lakhs. Last date of hearing, I had filed one memo of calculation. But it is mistake, communication, correct. Memo of calculation was not right. Thereafter, I have verified with all the amount that they have paid. According to the interim order granted by this honorable court,
Is it a case where it is 10,000 and 5,000 was directed to be deposited?
No, we are already paying 20,000 plus 10,000. in
Let's see,
CMS
what's the
case,
order,
my lord.
let's just see what is the earlier order passed.
30,000 was the amount granted by the trial court.
Yes.
1 minute,
20,000.
1 minute.
One.
Latest order is on 19/7.
Yes, madam.
Interim order is 10,000.
Yes, madam.
Interim order is 10,000.
Yes.
So as per that 10,000, you have cleared all the arrears?
No, we are still continuing. Other,
Then why should
no,
there
we
be
are paying every month 10,000 rupees.
No.
Yeah.
No, court says paid, any arrears were not directed to be paid, clearing arrears also.
Yes.
No, 10,000. When is the petition filed before the trial court?
Trial court is in 2013, my lord.
So 2013 to now.
We have out of 26 lakhs, we have paid almost 19 lakhs. my lord.
Out of
26 lakhs.
26 lakhs, you have paid
Paid
19 lakhs.
19 lakhs.
No, whatever is the remaining amount that should be taken, please argue on the merits of it.
My lord, we have to file the affidavit also. I could not contact the client because he's unwell and he's held up. in
What is the
Hyderabad.
affidavit that has to be filed
No, that he is paying the money.
regarding payments made to
Yeah.
respondent? No, what we do is it's a the 2018 RPFC, we'll dispose it off. Whatever is the remedy available to the party, they will take, they'll file the execution petition, basing on the orders passed by this court. Yes. Where is the order?
My senior colleague is out of station, my lord, so a date may be given.
Huh?
Affidavits, last date of hearing.
No, that all those affidavits, now how many days the matters will be kept pending here? 2018, now we'll decide whether the order is right or wrong. If execution, whatever the remedy available to the parties, they will go ahead with that. When do you want?
Maybe 2 weeks time may be given.
Not 2 weeks time.
1 week, 1 week.
Post this matter on next month. No further adjournment will be granted. It's an RPFC of 2018. Yes, next.
Much obliged, my lord.
Holiday, Tuesday then.
Yes, sir.
Yes, next.
Cell number 4. Hearing on preliminary hearing B group, Naveen TK, party in person.
This is a writ petition of 2013 for non-rectification of the office objections raised on IA number 2 of 14. The matter is still pending before the court. No representation. Post for dismissal tomorrow. Yes, next.
Cell number 5. Or Anil Kumar, party in person.
Wherein the respondent. Writ petition plots have become infructuous because the wife herself has withdrawn the petition, not so all the writ petitions not.
Becomes infructuous. What are the petitions? What are these all arising out of?
That's arising out of a criminal miscellaneous case.
Oh.
Which the criminal miscellaneous itself is disposed of. So it may be treated as.
No, why you so many execution petition is filed? All is arising out of
Not
execution.
have the exact copy.
Give that.
ಮೇಡಮ್ ನಾನು ಪಾರ್ಟಿ ಪರ್ಸನ್
ಹ್ಮ್.
ಇದು ಸಿಮಿಕ್ಸ್ ಕೇಸ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ನಡೀತಿತ್ತು, ಅದು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ. ಅದರಲ್ಲಿ ನಾನು ನೀವು ವಿಡಿಯೋಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದಕ್ಕೆ ಕೋರ್ಟ್ ಮುಂದೆ ಅರ್ಜಿ ಹಾಕಿದ್ದೆ.
65B application has been rejected by lots of the petitioners. Now on that
So now all these IAs, these are IAs arising out of this criminal misdemeanor.
Yes, all the.
Yes. The land counsel with the respondent and as well as the party in person are present before the court. It is submitted that all these writ petitions are arising out of the IAs filed in criminal miscellaneous number 459 of 2012. The same came to be withdrawn.
ವಿಡ್ರಾ ಮಾಡ್ತಿಲ್ಲ ಮೇಡಮ್. ಅದು ಸಿಮಿಕ್ಸ್ ಕೇಸ್
Tell him no.
ನಾನು ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಇದೆ.
Give that. Give that.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ. ಮೆಮೋನು ಇದೆ ಮೇಡಮ್.
It is submitted that the wife had filed a memo of withdrawal seeking permission to withdraw the petition. Accordingly, considering the same, the court had dismissed the criminal miscellaneous as withdrawn. In the light of the said order dated 31/8/2018, all these writ petitions are dismissed as infructuous. Yes, next.
Cell number 8 adjourned, 6 adjourned. Cell number 7 adjourned, 8, cell number 8.
Yes.
For approval petitioners, my lord, currently not in short accommodation, we must take steps.
The service of harm. 2017-16, still you say that you require time.
Short accommodation. Can we
How short you want?
A week's time if I leave it.
Pose this matter after a week, on Tuesday, next week. By the time, if the steps are not taken, the writ petition shall stand dismissed without further reference to the court. Yes, next.
Cell number 9. Narasimha Murthy, GV.
Withdrawn.
For withdrawal.
Already, my lords, filed the memo for withdraw the petition.
The memo is filed, seem to withdraw the MFA, and the memo is taken on record, and the appeal is dismissed as withdrawn. Yes, next.
Cell number 10 disposed, cell number 11 adjourned, cell number 12. Sridhar Murthy, HR. M. Nagesh.
Yes.
Giridhar SV.
Plaintiff's appeals. What has happened is that a very perfunctory order, the application for injunction has been rejected. Suit is filed asking for a declaration of ownership and to say that several sale deeds are not binding on the plaintiffs. There is a judgment of this court which says that if I'm not a party to the sale deed as is our contention, then I don't need to seek specifically cancellation. On that basis, the suit has been filed in the year 2020. Injunction application has been considered, or I should say, not really been considered. If the court is pleased to see the order, please be kind enough to take the impugned order. The page 16, please be kind enough to come to 24.
Please come to the cost title one.
Yes. The court have the appeal.
Who are the defendants?
Yes. These are persons who claim that they have sale deeds in their favor.
All of them.
Yeah, no.
All of.
The first set of them are persons who claim sale deeds from the plaintiffs.
Looking at the cost.
Yes, yes, I'm pointing it out.
That's
And
it.
the subsequent persons are all persons who are subsequent purchasers from. That is.
All are purchasers.
All are purchasers in some form of.
First or second.
First or second. One of them is a developer, but essentially all of them have some interest.
No, all the, for whom you are repairing,
13, 14 and 15.
they're the subsequent purchasers.
They're really developers who have also alienated further.
13, 14 and
15.
15. What about the other respondents? You are repairing for 16 to 18. What about 17? 16 to 18. Then who, then 19 to 24?
IAS were confined only to these 6 defendants.
So.
IAS interim reliefs were sought for only against these defendants.
Also, I appear for
What
the
is the
first
dispense with
correspondent.
respect to 19 to?
Many of them were placed ex parte in the trial court.
1 to 12, as well as 19 onwards.
Already order is passed?
Yes, yes.
If the court is pleased to see the
I
application.
appear for the first respondent.
34.
Yes.
Page 34, ink page 34 of appeal 5926. The injunction was sought against 13 to 18. And they're all represented.
The defendants 13 to 18.
The concerned defendants
From
are,
alienating the scheduled property.
that's it.
Please come to the order now.
Please be kind enough to look at the order. Please come to page 24. Paragraph 6 records the facts. I can just read that out so that it may be convenient for the court.
We'll read from the beginning so that the facts can be clear.
Please. Para 6. Plaintiff has filed a suit seeking declaration that he is the absolute owner of half undivided portion of the suit schedule property and order a permanent injunction restraining the defendants from interfering with his possession over the suit schedule property over survey number 173, measuring around 15 acres 33 guntas in Bukkasagara village, Anekal Taluk. Plaintiff, apart from these reliefs, has also sought for various sale deeds said to be executed by him and the brother of the plaintiffs as null and void and not binding on the plaintiffs. Plaintiff has specifically contended.
1 minute, what does this mean? Various sale deeds said to be executed by him. Said to be means you are denying that.
Yes, we are saying that it was not executed, that there was some forgery. The plaintiff has specifically contended that he and one Balappa are brothers and they were cultivating the suit schedule property in survey number 173 measuring 15 acres 33 guntas as tenants. And as per order dated so-and-so, it's 1975-76, occupancy rights in respect of the entire suit schedule property has been granted in the names of the plaintiff and his brother Balappa jointly, and thereafter the revenue records have been mutated in their names jointly. Plaintiff has contended that he and his brother Balappa have been in possession and enjoyment over the suit schedule property. Plaintiff has contended that as there was drought in their area, plaintiff could not continue his life at his native, and he along with his wife and children left their village and started living in Hosadoddi village, Kanakpura Taluk. It's a neighboring taluk. The plaintiff has contended that his brother Balappa has died by leaving his wife and children and defendants 18 to 24. Plaintiff has contended that by leaving their village, both he and his brother Balappa planted eucalyptus saplings in the scheduled property so as to harvest the plantation in future. Plaintiff has contended that the defendants are herein noticing the absence of the plaintiff and his brother Balappa from the village have created false and fabricated documents and have created sale deeds impersonating the plaintiff before the jurisdictional sub-registrar, and by playing fraud upon the plaintiffs have created title deeds to defeat his legitimate right. Plaintiff has contended that the defendant one has created the sale deed dated 25/7/94 in respect of 3 acres 2 guntas. Defendants 2 to 5 have created 2 sale deeds dated 24/7/94 in respect of 2 acres 37 guntas and 2 acres 25 guntas. Plaintiff has contended that the defendants 6 to 10 each have created the sale deeds dated 25/7/94 for 1 acre 5 guntas, sale deed dated 28/9/94 for 1 acre 5 guntas, sale deed dated 29/95 in respect of 1 acre, and sale deed dated 29/95 for 1 acre. Plaintiff has contended that these defendants have created the above sale deeds by impersonating him and his brother and by playing fraud on them. In turn, have executed other sale deeds and joint development agreements. So the plaintiff has come up with a suit seeking declaration that he is the absolute owner of half portion of the scheduled property and the order of permanent injunction restraining the defendants from interfering with his possession over the suit property, along with declaration that the sale deeds said to be executed in favor of the defendants are null and void and not binding on. Defendants 13 to 15 have filed common written statement. Defendant 18 has filed written statement, and defendants 16 and 17 have adopted the written statement of 18. Defendant 13 to 18 in the written statements have contended that the suit property survey number 173 measuring 15 acres 33 guntas has been granted jointly to both the plaintiff and his brother Balappa. So therefore, my title is not disputed. These defendants have specifically contended that both the plaintiff and his brother have executed sale deeds alienating the entire 15 acres 33 guntas in favor of third parties and the defendants herein and other purchasers. The defendants 13 to 18 have specifically contended that the sale deeds of the year 94 purchasers have been put in possession, and now after getting conversion of the suit property are developing it, and at this juncture, after a long time, the plaintiff has come with a vexatious suit only with the intention to harass them. The plaintiff has filed a suit seeking declaration that he is the owner of half portion of the suit schedule property measuring survey number 173, bearing survey number 173 measuring 15 acres 33 guntas. Plaintiff has sought the order of permanent injunction restraining defendants from interfering with his possession over the entire extent of 15 acres 33 guntas. Plaintiff has sought that the sale deeds executed in the names of 1 to 10 and in turn the other defendants commencing from the year 94 are null and void and are not binding on him. Plaintiff has specifically contended that the sale deeds have been created impersonating him and he has never executed any sale deeds in respect of the scheduled property. Plaintiff has sought declaration of the ownership over half portion of the scheduled property. Plaintiff nowhere in his plate.
I have seen.
I'm sorry, I'm grateful. Now please permit me to just point out para 8 is the only paragraph giving any reason whatsoever. According to me, there is absolute non-consideration. And this is a fit case for perhaps even remand of this application for the reason that there is no consideration whatsoever. The court has read this, it would say.
Come to your plane.
Please be kind enough to come to the plane. In fact, in page 28, the court records that I have not sought for declaration of ownership. That is factually not correct. Please be kind enough to take the amended plaint that begins at page 68. I'll skip all the parties and so on and so forth. Please be kind enough to come to page 74, paragraph 8.
Yes.
And then there are two paragraphs numbered as 8. And then over the page at page 75, again para 8. And thereafter, in para 9, what are the documents said to be fraudulent are all set out. Then, please be kind enough to come to
Para 10.
yes, para 10, where I mentioned in page 83 that fraud
Please
vitiates.
tell the court.
Yes.
How did you come to know, right from 1994, when there is change of ownership of the property?
Yes.
Then how you are not known about it from 94 to 2020?
That is mentioned in para 11. That is what is,
Please read
it
that.
is very, I'll just read it out. It's not a very elaborate description, but this is what it is. Further, the plaintiff's father was not even aware of the aforesaid transactions since he was away from his village and had settled in another village. Recently, when the plaintiff's father accidentally met one of the children of his deceased brother, realized that entire revenue entries in respect to the suit property has been changed in the name of the aforesaid defendants 1 to 24. It is pertinent to state that the physical possession still remains with
What have you filed to show that the physical possession is with you?
Insofar as physical possession, what was placed was some photographs of the land. They've also placed some photographs to show that they've developed a tar road and so on and so forth. So that is one part of the story. But what is important is that please then come to para 12 and then 14. The cause of action is set to have arisen in January 2019. And the suit came to be filed in January 2020 because it took some time to collect the records. Now, therefore, my respectful submission is this. I have pointed out that there is clearly fraud that has been played and I was not even residing there. Now, please be kind enough to look at the documents which have been placed by, now first important aspect is none of them challenged my grant. That the grant was in my favor. Nobody says that the grant was not in my favor. Please be kind enough to take the compilation of documents that have been filed. If the court is kind enough to take the compilation placed by, along with a memo by the respondents 16 to 18 first. I'm sorry, I don't have a date stamp on this. Sorry, my learned friend is also not able to supply the date.
Yeah,
The court has stamps of date. Please look at the first document. That is the actual registration of a tenant as an occupant. Form 10.
Your title is not disputed.
Yes, that's not
You are
disputed.
disputing their sale deeds.
Yes. Now, please straight away come to page 8. These are the first set of sale deeds. All of them are in 94, 95 that have taken place. This, according to me, is not my signature and so on and so forth.
What is the name of this plaintiff?
Plaintiff's
Papaya.
father is Papaya.
Plaintiff is Popeye.
I stand corrected. Plaintiff is Papaya. He's no more. I meant to say the appellant's father is Papaya. I'm grateful to my lawyers. Papaya passes on, so therefore his LRs are on record. Now I can straight away point out from some other sale deed that there is some variance in signature. Now, of course, whether that was affixed while affixing a certified copy by somebody at the sub-registrar staff, or was it in fact his signature, is something that needs to be tested in trial. If I'm able to show prima facie that there are two sets of signatures and they're not compatible to one another, my respectful submission is something that the court should have considered. That's my first submission. Second, I have put together a case to say that fraud has been played on me. I've made certain averments.
What from you're saying that the fraud is played?
I'm sorry?
Which signature? You're saying that the fraud is played prima facie.
Yes.
Which signature you say that?
Yes, if the court is kind enough to take the compilation from page 8, all of these I say are not my signatures.
No, that is your denying.
Correct.
You say on the face of
Yes,
it.
I'll point out
It shows
one.
that they are not, that there is variance in the signature. In fact, this page number 8 signature and the plain signature appears to be one and the same to a naked eye. No, Mr. Senior Counsel,
Yes.
please come to.
Yes. can I just show the certified copy of the plaint versus?
No, yes, please.
That
come.
may be the right comparison. I don't think we should labor on anything else.
Yes,
No, I'm sorry. This is the amended.
please
plaint.
come to page 66.
Yes, please, very well. I am at page 46, but 66 also suffices. 66 also serves the purpose. Yes. This was when he was 85 years old in the year 2020. This is supposed to have been in 95. So there's a difference of 25 years. So there is some variation in signature invariably that there will be. Page 8 of the
The
document
strokes
comparison.
are so different.
Yes.
It appears to be for a naked eye as it is.
Now, may I just also show there is a compilation that's been tendered by this is respondents 13 to 15 in MFA 5926.
No, from these documents.
I'm
let's
just
continue this.
I'll just show one document to the court. And so that
Sure, in
yes,
this
yes,
compilation
absolutely.
we'll see.
My respectful submission is that even this sale deed and this, the court may find that if the court is pleased to see that if in 95 itself there is some shaking in the hand and so on and so forth, in the year 2020 the variance is quite marked. So therefore my respectful submission is that that is the first point that I may bring to the court's notice. Please be kind enough to look at page 148 of the compilation tendered by my esteemed friend, Mr. Sebastian, respondents 13 to 15.
No, what I'm saying is.
Yes.
What is before me is.
Yes.
Filed on behalf of.
Yes. Yeah, may I just show one more sale deed where the variance is stark? I'll just show the court one more sale deed. Please look at page 148 of the compilation tendered by respondents.
This is other compilation.
I'm sorry?
I'm asking the court officer.
13
Where
to
is the other compilation?
I was told this was served on us yesterday or day before yesterday. I'm not sure.
Is this the one?
Additional document.
Additional documents in support of statement of objections.
Additional documents filed by the defendant number 30.
Let's see. No, there is no 148 in that. Is that? Yes, 140.
148.
95. Sale deed 95.
This is a sale deed of the year 95.
Yes.
My learner friend, it is.
This is affixed
No, no,
apparently by the sub-registrar's office.
Names are written.
I'm just coming. This is what
Not
their
the
contention
signature.
is. I mentioned that at the beginning. I'm fully conscious, sir. I'm not at page 148. This is what happens is back in the day, they used to write out the entire sale deed as by way of certified copy. Then it begs the question, why was one deed written out like this while some other deed is photocopied, and why the variance? Now, of course, I am not for a minute contending that this is the signature of the plaintiff. No, that is not my contention. But my contention is that sale deeds which are contemporaneous, one is issued by virtue of a photocopy, one is not issued by virtue of a photocopy. These are matters that need to be tested in trial. And ultimately, to answer the court's question and what fell from the court about the variance or lack of variance, depending on the point of view, between the plaint signature and the sale deed at page 8 of the first compilation that I showed the court, my respectful submission is that there is a variance and it is something that needs to be tested in trial. Second, I found out about it only, I point out in 2019, and thereafter I've collected the
How you
document.
come to know?
But that is narrated in the plaint. Please be kind enough to
Para
see.
number 11.
Yes, paragraph 11. That is the case that's made out. My submission is this. As we speak, there is no consideration of any of this by the trial. All that the trial court says is,
No, again,
Yes.
now we will look at your affidavit in the IA.
yes, it is pretty much the same as what is said in the plaint. It's pretty much the same as what is said in the plaint. So the court may take it that if my plaint is not considered, my IA is not considered. Please look at the order for a minute. Can I just draw the court's attention to this? Please be kind enough to come to page 27.
Yes. I've read the whole
Yes,
order.
may I just show, I'll just read 4 or 5 sentences from it.
Yes.
Please see last 4 lines at page 27.
Yes.
Plaintiff has sought declaration of the ownership over half portion. Plaintiff nowhere in the plaintiff specifically contended whether his brother Balappa has executed the sale deeds or even he was impersonated and thereby impersonating him and Balappa, the sale deeds have been created. Frankly, this is a new creation that the court has come up with. It is nobody's case that Balappa impersonated me, and even if he had, that the sale deed is vitiated by fraud. Let me assume that this is what I have to go with. Even then the sale deed has to go. Then plaintiff who comes to court must come with clear-cut case, keeping in mind the final adjudication of the dispute between the parties. In the present suit, right of the parties cannot be finally adjudicated if the plaintiff has not sought declaration of their ownership. This is factually wrong. I have in fact sought ownership. I have in fact sought declaration of my title. Factually incorrect. Moreover, the sale deeds are of the year 94 and present suit is in the year 2020. That too in respect of 15 acres, 33 guntas, a large extent of land. Therefore, at this juncture, please mark this, there cannot be any final adjudication of the rights of the parties. Of course not. That's why I'm seeking temporary injunction. And if temporary injunction is granted, it would be over uncertain period of time. I am really baffled by this. Temporary injunction is still the disposal of the suit. If the court passes a timeline saying dispose of the suit within a year, I'm bound by it. Not always is it a case that the High Court has to give a direction. The trial court may say, yes, I'm granting injunction, but I'll make sure that you complete the suit. If you take adjournment, I will have the order vacated. Fair enough. To say this really baffles me. How does a trial court say that it is a temporary injunction, but it will be over an uncertain period of time? How does a trial court say, in the light of what I've sought for in prayer A, that I have not sought for declaration of ownership? How does the trial court say that I have not specified what the...
No, what exactly the court wants to say is, this is a suit of 2020.
Yes.
On an interim injunction, now, for example, it is not granted. If it is granted, no, till 2024, it would have been before the court. So there is no certainty.
No, there is a
when
reason for
would
that.
be-
We moved the injunction application a little later. I will point that out from the list of dates. The injunction application...
There are cases not today in the list, 2012 injunction is still here.
I could see that. I could see that.
Probably that's what the court is referring
That
to.
may I say this? I don't think that should be a consideration or that is a consideration. And the reason I say that is, in India, we don't have guarantee of title. It is what it is. When we buy, we are expected to exercise due diligence. You know that I am the grantee. You say that I have signed. I am saying that this is not my signature. The court comes up with a new case.
What is the due diligence by a purchaser? Now, what the purchaser will do, he will look at your grant, then after that your sale deed.
Of course.
Then if it is even partitioned or not partitioned, they don't have to look at it because both the brothers have signed on that. On the
That's
sale
what
deed.
they say. That is what they say.
That's what, no, there is as far as the due diligence
Yes.
and is a bona fide purchaser, there cannot be any other reason for them not to believe your title to the property.
No, I bow down to that. But all I'm submitting is that here is a case where the reasons given by the trial court are absolutely baffling.
Yes.
And if that is so, my respectful submission is that it's a case that deserves to be reconsidered by the trial court.
Yes.
I given a synopsis of
Yes.
the documents which I have filed,
Yes.
along with my statement of objections.
Yes.
Rob, you are also my turn. Give me the synopsis.
These are all about the documents that I have seen in the order.
What I say,
Huh.
7/12/2098,
7/12.
2098, 3 properties are granted.
1 minute. 7/12/2019.
1978.
First page.
1978.
1970.
1978. 3 items were granted in favor of both the brothers, Papaya and Balappa. Item number 172 is 6 acres 37. 173 is this subject matter 15 acres 33 gundas. 189 is 2 acres 3 gundas. Because both of them sells. Survey number 172 and 189. On 19/3/2019, under 2 sale deeds. One in favor of R. David and another in favor of Ramakrishna.
No. When is that? 2 sale deeds in favor of?
in favor of R. David.
That's not in question. That is not in question.
That is not in question. The entire survey number 172 and 189 are sold under two sale deeds in 1990. Now, below the next page is about the sale deed of various sale deeds.
15
in
acres of
respect
land.
This property. Then your lordship will see.
Yes.
Balappa died. The younger brother died on 12/12/1997. After all these sale transactions. My lord, on 5/5/2011, your lordship will get at page 3.
Yes, yes.
The children of Balappa,
In
Srinivas and others,
in respect of 172 and 189, they file these suits.
they file a suit. There they enter into a compromise with the developer and the suit is still pending. No progress. In 2014 and 2015, page 4, the legal heirs of Papaya, who has now come on record as the LRs of Papaya, they have challenged these sale deeds. Which one? Survey number 172 and 189. Children of Balappa has filed a suit in 74
for partition.
11, and children of Papaya has filed in 2015. That suit is simply pending without any progress.
This OS number, this is for partition.
It's a partition suit. They claim rights, and that our interest
That
is not.
this encumbrance certificate and all filed with regard to the sale of the properties.
Yes.
15 acres.
Yes, my lord.
Is it filed?
Now your lordship,
No. No, in
they don't touch these 15 acres at all.
no, this OS number 1185/2015 is also in respect of 172 and 189.
172 and 189.
Not this 173.
Not this property is not touched upon either by the LRs of Balappa or LRs of
Yes.
Papaya. My lord, your lordship will see page 3 down on 3/11/2014. Papaya obtains the encumbrance certificate in respect of
173.
173. He doesn't file a suit. His children do not challenge this suit. That means they had no contest about these entities in respect of 173. Papaya filed the suit. Now, this suit by Papaya is filed on 7/1/20.
Yes.
IA number 1 was for injunction to restrain alienation and nothing beyond that. My lord, he died on 3/5/2020.
Yes.
His children have filed application to bring themselves on record, setting aside abatement, etc. IA numbers 2, 3, and 4.
Yes.
And during the pendency of those applications, they have filed IA number 5 on 5/8/2021.
Yes.
For restraining them from developing, even before they could come on record as LRs. On 18/8/21, IS 2 to 4 were allowed. And your lordship sees on 12/7/23, IA number 1 and 5 were considered and a joint order was common order was. So my first submission as far as IA 5 is concerned, before coming on record as LRs, they have filed disability. And that is not either brought to the court's notice by either side of it. Secondly, these sale deeds, Balappa and these, both of them have signed it. He says in paragraph 11 of the suit that recently he came to know. In 2014 itself, he takes encumbrance his own documents, which is filed along with the court. 19, he obtains the certified copies. 20, he files the suit. Yes. Well, there is absolutely no justification in interfering. Ultimately, if they succeed, it is something different. They will get right against the parties, whoever succeeds at whatever stage. Several crores of rupees are invested by the developer, and joint development agreements are executed, and lands are converted. There is no defect in the order rejecting the IA numbers.
You want to respond?
Well,
Who are you?
The-
Who you're representing? Huh?
16 to 8.
That is all of you are sailing. All of you are sailing together.
Sailing together.
And then what reply you want?
Just respond.
Yes.
Court may take it that they're all, perhaps the dates and the extent are different, but otherwise I don't think
Not
substantially.
necessary for this application.
For this
Separate
application, I don't think,
separate
the court
argument,
needs to
not
go into
this.
which sale deed is in question. I don't think that's in question at all. First submission insofar as the attempt to drive a wedge between Papaya on the one hand and Balappa on the other hand. My submission is that it does not benefit them.
What do you say about the encumbrance certificate?
The encumbrance certificate has not been marked. We don't know who's obtained it again. I have not come across it. The one encumbrance certificate that has been placed by them indicate that it's 2018-19 year of grant, which is akin to what I'm saying, that the year I found out is 2019 January and I filed the suit soon after that. So therefore that
But
may not.
Not that.
May I just tell you the encumbrance? I am not too sure it has been placed with the
11
documents.
2014.
I'm not sure it was placed with the documents. Let me just.
Papaya applied and obtained certified copies of the encumbrance certificate in survey number 173.
That is mentioned in the.
Page number 252 to 254. 252 to 254.
You have produced it the court, trial court. And the date is.
This was definitely not done by us. In any case, of course, this doesn't bear any signature. Any person by name Papaya can obtain
Trial
it.
court does not be security. What you have produced is wrong. We will surrender to you.
I am not saying that. All I'm saying is that I am not accepting this. It's a matter of trial. That's what I'm saying. If you please surrender, I have no difficulty. Let that submission be recorded. No, this is not the way to make a submission. That is a matter of trial. That is precisely my submission. You are saying, and it is their document. It is not my document. Their document says that Papaya has applied. Which Papaya, we don't know. Nonetheless, according to us, it is not us. Then coming to the next submission made insofar as seeking to drive a wedge between Papaya and Balappa, my respectful submission is that does not inure to their benefit. Once they accept the fact that I am a joint grantee, joint owner of the land, without me, they cannot progress further. If they've made a deal with Balappa, that is at their peril. And it seems to be that is what has happened, because why would the trial court otherwise indicate thus in its order? There was no occasion for the trial court to make that remark and say that who impersonated, was it Balappa who impersonated or someone else, is not clear. But there was no occasion to make that remark unless they have perhaps cut a deal with Balappa, which again is something that they need to bring out in, and it's a matter that has to be brought out in trial. Today, please see the consequence. If I am not protected, even if the suit is decreed, what is to happen? There will be further alienation to others also. That is all I am seeking some protection against. Great.
Come. Anita? This is also not functioning today. No, this is not on. Oh, now it is on. Agreed with the orders passed in IN number 1 and 5, invoice number 34 of 2020, dated 12 July 2023. The plaintiff is before this court. The plaintiff had filed suit seeking partition, seeking a declaration that he is absolute owner and lawful possession in half undivided portion of the sole scheduled property, and also declare that the sale deeds executed in favor of the defendants are forged, created and concorded documents, and they are null and void and are not binding on the plaintiff. and also sought for a permanent injunction, restraining the defendants or their agents or their legal representatives from interfering with the peaceful possession and enjoyment of the scheduled property. And also, they sought a relief to declare official memorandum dated 22/8/1991 as null and void and is not binding on the plaintiff. It is the specific case of the plaintiff that the plaintiff's late father acquired the suit scheduled property along with his brother Balappa as per grant order dated 7/12/1978. The said grant of lands were made under section 48A within brackets 5 of the Karnataka Land Reforms Act 1961 by declaring the plaintiff's father and his brother Balappa as the tenants of the suit scheduled property. As the lands were not demarcated, and the plaintiff along with his brother was cultivating the lands jointly, occupancy rights in respect of the lands granted jointly. Due to severe drought conditions, shortage of water to do agriculture activities, forced the plaintiff's father to look for livelihood in other places. Since the plaintiff's father is an agriculturist, the plaintiff's father had no other option but to go out of his own village and look for livelihood as agricultural labor in other villages. The plaintiff's father has settled with his family members in Hosadoti village, Kanpura Taluk, Ramanagaram district. In the meantime, the brother of the plaintiff's father, Balappa, expired, leaving behind his children and his wife as his legal heirs. And the wife and children of Balappa have succeeded to their share as per the grant order dated 7/12/1978. While leaving, they have planted eucalyptus saplings in the suit scheduled property. The plaintiff's father was under the impression that he would come back and cut the trees after about 3 decades, since the chances of the saplings surviving severe drought conditions was very slim. Taking advantage of the absence of the plaintiff's father and his brother, the defendants have created false and fabricated documents and have created sale deeds by impersonating the plaintiff's father before the jurisdictional sub-registrar, and they have played fraud upon the plaintiff's father and have created title deeds to defeat the legitimate right of the plaintiff's father. It is stated that that defendant number 1 has created sale deed dated 25/7/1994 in respect of 3 acres 2 guntas. The defendants number 2 to 5 have created 2 sale deeds dated 24/7/1994 in respect of 2 acre 37 guntas and 2 acre 25 guntas. The defendants 6 to 10 each have created the sale deeds dated 25/7/1994 in respect of 1 acre 5 guntas. Another sale deed dated 28/9/1994 in respect of 1 acre 5 guntas. Another sale deed dated 29/1995 in respect of 1 acre, and sale deed dated 29/1995 in respect of 1 acre. And he sought the relief as extracted in the above paragraphs, seeking a declaration that he is the owner and the said leads are not binding on them. They have come up with the IA seeking an injunction restraining the defendant number 13 to 18 from alienating, putting up any construction for the suit scheduled property pending disposal of the suit. The trial court, while dismissing the application filed by the plaintiff, has observed that the plaintiff has sought the sale deeds executed in the name of defendants number 1 to 10 and in turn to the other defendants commencing from the year 1994 are null and void, and they are not binding on them. And it is the case of the plaintiff that the sale deeds have been created impersonating him, and he has never executed the sale deeds in respect of the suit scheduled property. The plaintiff had sought declaration of his ownership or half portion of the suit scheduled property. The plaintiff nowhere in the plaint has specifically contended whether his brother Balappa has executed the sale deeds or even he was impersonated, and thereby impersonating him and Balappa, the sale deeds have been created. The plaintiff who comes to court must come with clear-cut case, keeping in mind the final adjudication of the dispute between the parties. In the present suit, the right of the parties cannot be finally adjudicated, as the plaintiff has not sought declaration of their ownership for the entire suit property, or he has not sought for partition of his share. Moreover, the sale deeds are of the year 1994, and the present suit has been filed in the year 2020. That too in respect of 15 acres, 33 guntas, which is a large extent of land. The court felt that at that juncture, there cannot be any final adjudication of the rights of the parties. And if the temporary injunction is granted, it would be over the uncertain period of time. Therefore, the court felt that the plaintiff had not made out a prima facie case in order to seek the order of temporary injunction, either restraining the defendants from alienating or putting up any construction or the suit scheduled property. In absence of the prima facie case, the balance of convenience, the relative hardship are only imaginary, and accordingly dismiss the application. Next paragraph. Then senior counsel appearing for the appellant plaintiff submits that the court had failed to consider the case of the appellant plaintiff and its proper perspective. It is submitted that the findings that are given by the court is some of the findings that are given is nobody's case, and they are not the relevant consideration for granting injunction. It is submitted that the finding of the court with regard to whether it is alone the plaintiff's father or whether the Balappa is also impersonated, and finding that about coming to the court with clean hands. He submits that when they have that they are not genuine for consideration for an application under when an application is filed seeking injunction. It is submitted that they have made out a prima facie case showing that there is a grant in favor of the plaintiff's father and his brother. And that is way back in the year 1978. Occupancy rights were granted jointly in favor of both the brothers. And even the defendants also have not disputed any of those facts. When he is raising a serious concern, that is that the fraud is played by the defendants, and the delay of the sale deeds of the year 1994, and the suit is filed in the year 2020. in case of fraud, the delay will never be a ground for non-suiting or for not granting injunction. It is submitted that if if they proceed with the construction and third party rights are created, it would cause a lot of hardship to the plaintiff. This was, Legislative Council has drawn the attention of the court to the plaint and also the sale deeds that were executed in the year 1994. And it is submitted that there is variation in the signature of the plaintiff's father. And the manner in which the sale deeds of the same year, in which in one of the sale deeds, the signatures are found. In the other sale deeds, what was your submission?
Question was that one contemporaneous sale deed. One said there is a photocopy, certified copy issued by way of issuance of photocopy. In the other said it is drawn out by the or written out by the sub-registrar, and no reason is how that's the matter.
It is drawn out, it is written by the sub-registrar. The names are mentioned as written by the sub-registrar. Basing on this, it is submitted that it's a clear, by placing all this before the court, you could make out a prima facie case. The balance of convenience being the original grantees is in their favor. And unless and until an injunction is granted, they would be put to irreparable loss. Next para. Senior counsel appearing for the respondent. Before that, the defendants, as far as defendant number when is that order passed? Dispensing with notice to respondents.
I don't know if there's an order dispensing. They were placed, many of them were placed ex parte before the trial.
No, before this court, was it
In the
He went to detour on 19 to 28.
in this appeal, I'm sorry, I just appeared today. I do not. I'm sorry. I should have verified that. I'm sorry. I do not. Old notice was dispensed, which I'll have to verify. Sorry.
They were dispensed with for the reason that the relief were sought.
What is true? No, I just want to know which order it is done, to record it in the order.
15/9/23 is mentioned.
15/9/23.
15/9/23.
Is there?
Yeah.
A memo is filed. Next para, seeking dispensation of service of notice to respondent number 1 to 12 and 19 to 28. That the memo is taken on record. And service to respondent number 1 to 12 and 19 to 28 is dispensed with at the risk of the appellant by order dated 15/9/2023. And the court on that day had issued notice to respondent number 13 to 18. 13 to 18. On
The
18/4/2024.
There's an order of status quo. On 15/9.
There is an order of status quo that day.
So
Then on 18/4/2024. The order dated 15/9/2023 passed. And so far as dispensing of the notice to respondent number 28 is recalled. And there was a direction to issue hand summons to respondent number 28. And it was ordered that the registry is directed to issue hand summons to respondent number 28, calling upon her to produce a gift deed dated 7/9/2005 and 27/11/2009, executed by Sri Papaya in her favor, as well as in favor of her mother, Srimati Tayamma. And the interim order of status quo granted earlier is extended till the next date of hearing. Why that 28 is necessary for the?
I'll just point out, please be kind enough to see what had happened was that there was a.
To see
The
the
original
documents
gift deed.
executed by that was a gift deed in favor of D28.
By whom? By Papaya?
Papa.
Then for this application, why are, how are they?
No, it should have been by Balappa, because Papa, the D28 is the descendant of Balappa. So the court asked if that can be placed. We said, I do not have it. That is why the court has recalled it. That the court would get it order dated 18/4.
The limited purpose of, so far the notice 28 is not issued. The limited purpose of the court to issue notice to respondent number 28 is to look at a gift deed executed by Papaya. Executed by Papaya. Now, the present injunction petition is filed seeking injunction restraining the defendants
13 to 18.
13 to 18, 13 to 18. In that view of the matter as 13 to 18 are represented before the court. And at this case, this court is not inclined to look into or go into the aspect of the gift deed as far as this application is concerned. Next. Who is he appearing for?
I appear for 13 to.
Are you 13 to 18?
13 to 15.
13 to 15, you? 16 to 18. The respondents 13 to 18 are represented by the senior counsel. And also there is a representation on behalf of 16 to 18. Then a senior counsel appearing for the respondent defendant submits that there is no dispute about the fact that there was a grant in the year 1978, that is 7/2/1978, in respect of 3 items of properties in favor of Papaya and Balappa. Those three, the 3 properties are, one is survey number 172 at measuring 6 acres 37 guntas, survey number 173 at measuring 15 acres 33 guntas, and survey number 199 measuring 2 acres 3 guntas. Now the suit scheduled property is survey number 173 measuring 15 acres 33 guntas. In respect of the other 2 survey numbers, that is survey number 172 and 189 measuring 6 acres 37 guntas and 2 acres 3 guntas, as the sale deeds were executed on 19/3/1990. Both the Papaya and Balappa. Thereafter, on 23/1990, Papaya and his brother has executed a sale deed in favor of one C.K. Ramakrishnappa in respect in survey number 172 measuring 2 acres 3 guntas and land in survey number 189 measuring 2 acres 3 guntas. Then thereafter, from 25/7 the 1994, 24/7 1994, 24/8 1994, 25/7 1994, 28 1994, 29 1995, again 29 1995, 13/11 1995, and 30/10 1995. Several sale deeds are executed in respect of survey number 173 measuring 15 acres 33 guntas in respect of some of the defendants. Then on 20/12/1997, the plaintiff's father's brother Balappa died. Thereafter, the children of Balappa had filed OS number 366 of 2011 on the file of the senior civil judge for partition of the properties in survey number 172 and survey number 189. And also declaring various sale deeds executed by the defendants are not binding on the plaintiffs. The said suits are pending, suit is pending consideration. It's still pending. It's pending consideration. It is submitted with the senior counsel that on 3/11/2014, the father of the plaintiff had applied and obtained certified copies of the encumbrance certificate in survey number 173, measuring 15 acres, 33 gutas. And on 17/10/2015, OS number 1185 of 2015 is filed by the legal heirs of Papaya seeking partition in survey number 172 and survey number 189. And also declare various sale deeds as null and void. Then voice number 34 of 2020 is filed by Papaya, praying for partition and declaration in respect of the property bearing survey number 173. That is measuring 15 acres and 33 guntas.
Before is the present suit.
Sorry. Then the plaintiff had filed the present suit, that is voice number 34 of 2020, seeking partition.
Not for partition. I think
Sir,
there's a
see,
typographical
praying
error
for
in the-
no, that's what you said.
In the list of dates, there appears to be typographical error. It's
Oh.
not for partition.
Has filed a suit for declaration.
Please. So
Declaration in respect of survey number 173, and that the sale deeds are not binding on them. Initially, he had filed IA number 1 under order 39 rule 1 and 2 CPC for interim injunction against defendant number 13 to 18, restraining them from alienating the suit scheduled property. On 3/5/2020, the plaintiff Papaya died. On 29/1/2021, the children have filed IA number 2 under order 22 rule 3 CPC, seeking permission to to come on record as a LRs. IA number 3 is filed under order 22 rule 3 CPC to set aside abatement, and IA number 4 is filed to condone the delay in filing the LR application. It is submitted that even before they came on record, IA number the present IA, that is IA number 5 is filed on 5/8/2021, praying for restraining the defendants number 13 to 18 from putting up construction and not to alter the nature of the suit scheduled property. On 12/7/2023, by common order, the IA number 1 and 5 was dismissed by the trial court. It is submitted that even before they're impeded, they have come up with an application seeking injunction, and the same was granted by the trial court. He submits that in the year 2014 itself, the father of the plaintiff, that is late Papaya, had already applied for an encumbrance certificate. In the year 2014 itself, they are aware of the encumbrance on this property, that the sale deeds that are issued, that are executed from 1994. In spite of that, they have kept quiet and not filed it, not questioned the same. And in the year 2020, the present suit came to be filed. He submits that after almost 30 years, after almost 25 years, the present suit came to be filed. Several transactions have taken place. The property has changed hands. And finally, the defendants 13 to 15, 13 to 18 have started the construction. And without any basis, just by claiming fraud. No, they want the entire developmental process to be stalled. It is submitted that the trial court had rightly observed that the defendant had failed to make out a prima facie case. And in fact, if an injunction is granted, it would cause irreparable loss and hardship to the defendants. Court had rightly considered all these aspects and dismissed the petition. He submits that there are no grounds made out seeking interference with the well-considered order passed by the trial court. Next para. Then counsel appearing for the defendants 16 to 18. 16 to 18 had advanced arguments in the similar lines, and he submits that the order passed by the trial court is a well-considered one and no interference is called for. Next, having heard the counsels on, senior counsels on either side, there is the material on record. The suit is filed for declaration and to declare the sale deeds which were executed, which are alleged to have been executed by the plaintiff's father and the uncle, stated right from 1994 to declare them as null and void, and they are not binding on them, as the father of the plaintiff had not executed such sale deeds. In the entire plaint, the plaintiff had stated about what is the source of title to the plaintiff's father and uncle, that is the grant in the year 1978. Later, he gives a list of sale deeds that are executed, and thereafter in the plaint, at paragraph number, from paragraph number 9, the details of the transactions are narrated. Then 10th paragraph speaks about, they narrate the fraud, stating that since they were injured by falsehood or deception, fraud vitiates everything which it touches and destroys the very thing which it was devised to support. And the law does not temporize with trickery or duplicity. Then at para number 11 of the plaint, it says that the plaintiff's father was not even aware of the transactions that are stated at para number 9. Since he was away from his village and has settled in another village, and recently the plaintiff's father accidentally met one of the children of his deceased brother, realized that the entire revenue entries in respect of the suit scheduled property has been changed in the name of the defendants. As such, they've come up with this suit. The senior counsel appearing for the plaintiff had submitted that there is variation in the signatures and a signature of the plaintiff's father in the documents, the plaint, in the sale deeds, the plaint, and some of the documents are where the names of the plaintiff, plaints of the father and the plaintiff's father and his brother were extracted there. Placing reliance on that, it is submitted that it clearly shows that the signatures are forged. This court is not able to appreciate the said contention at this stage. And looking at what has transpired from 1978, thereafter from 1994 till now, the version of the plaintiff at this stage cannot be considered as that an extent of 15 acres of land, they're not even aware what is happening to that, about the revenue records, and nothing has been stated about like how they have continued with the possession of the property. If had they been in possession of the property from the date in filing of the suit, now stating that the defendants are trying to construct that they're putting up the structures also shows that the defendants are in possession of the property. Just because they have alleged fraud while considering an interim application, the court has to, the court has to grant injunction. For seeking injunction and seeking the relief of injunction, he has to come up with a prima facie case, balance of convenience and irreparable loss. Now, the grant that is granted to their father cannot be a prima facie case. The affidavit, the plaint that is filed is absolutely silent about how they are not able to know about any of the transactions right from to 1994 till now. And in fact, when they have filed the suits in respect of the other properties, and when they are pursuing about the properties, why it is not in their knowledge, nothing has been stated. In just in a paragraph number 11, one simple word stating that they have come to know recently. In the considered opinion of this court, there is no prima facie case made out by the plaintiff for grant of injunction. Then coming to the balance of convenience, considering the sale leaves from the year 1994 till now, no, without a prima facie case, without a strong case or a case with regard to the diligence on the part of the plaintiff. Now, after these many transactions that have taken place, the courts cannot grant a temporary injunction restraining the parties who have purchased the properties right from 1994 and further sales that have been done. The submission of the senior counsel for the appellant that some of the findings of the court are not correct and there is no appreciation, that also this court cannot appreciate that the court had considered both the case of the plaintiff and the defendant in its proper perspective and rightly denied the injunction, and this court finds no reason to interfere. Accordingly dismissed.
Very good. May I just make 2-3 short submissions?
Both them are made.
Both appeals, both. Of course, it goes without saying.
A number 1. Second MFA is in respect.
It goes without saying, both appeals same order, right? I'm not.
Accordingly, both appeals are dismissed.
It's a common order, so I don't say otherwise. There is 1 or 2 small points I want to bring to the court's attention. By order dated 14/6, insofar as because the court observed about R28, and I'm just bringing to the court's attention, the court had directed that because we were unable to serve hand summons, there is an affidavit filed. Court had directed that summons be served, notice be served through jurisdictional civil court. It appears that's not being completed. May I
It's
just-
not. That I've recorded.
I'm grateful, as long as
I've
that is-
recorded that, it is not served, and the purpose of why the court wanted
I'm very
R28
grateful. I'm sorry.
for that.
I'm sorry.
So that's why, and this court finds no reason.
Because that contention was not advanced by my learned friend, therefore it's unnecessary today. So that's, I just wanted to bring that. Second one, may I just request this, any transactions be subject to the outcome, or if the court may just make that
It's
observation.
always there.
Of course, that is there. If the court,
These kind of things, no, nowadays this has become a trend in all these civil litigation.
I leave it to the court. The last one is that the observations made here should not influence the
Huh,
trial.
that would be Any of the observations made by this court for deciding this application shall not be construed as an expression of this court. And the court
So
will
great. I'm
decide
so
the
very
suit independent. Yes.
The status quo order is vacated.
No, it is not.
Absolutely.
Appeal is already got.
No. Now the
Appeal is-
appeal itself is all the,
By-
interim,
virtual
no,
dismissal.
in the end it will be there, all the IAS stands closed. Yes,
that goes without saying. I'm very.
yes, next.
Cell number 13,
Both the, I'm a face audit. Yes, 13.
cell number 13. Nasim Raju,
Appeal is against the government.
What is the suit?
That suit is for declaration and also a possession in respect of B schedule
Declaration and recovery of possession.
possession to an extent of 1 and 1/1/4 guntas. 1 gunta, because the
1
government
acre,
has
1
encroached,
gunta.
government has encroached my property.
Hmm.
And that encroachment was rectified, was notified in the survey conducted by the government itself. The survey department, Tahsildar has conducted the survey before institution of our suit. And the Tahsildar says, yes, the government itself has encroached my property to that extent towards the southern side. But since they are
When was that report?
that was conducted, even next to
The
that.
pendency of the suit.
No,
Oh.
before the suit. Thereafter only I filed a suit before the trial court seeking.
What is the date of that surveyor's report?
That survey is not, that is. At page 51, I have produced document number 9,
What time?
that the survey report
Typing?
page 50.
No, what is happening? Oh, while she was taking it was typing. Yes. Report is dated?
That is 21/7, 14/6/2023.
14/6/23.
14/6/2023.
23. When did you file the suit?
The suit was filed. That is on 23/6/2023.
23/6?
2023. 14/6 is the survey report.
Please come to the impugned order.
Please. And moreover, one more submission, lad. This honorable court was also directed to conduct the survey after admitting the appeal. By order dated, my lord,
What has happened after that?
that survey also confines, my lord, that they have encroached our land. During the pendency of this appeal also,
What is this attitude of the government?
No, my lord, survey, as per the survey report, there is no enforcement as such.
No, no,
I
no.
have filed my
Sorry, without
memo.
looking
I
to
have
the
filed memo
document,
Where
along
is
with
that?
that.
Where is that?
I have
No,
filed memo with.
no, that surveyor's report is part of the record.
It is a
That's
part
what
of record, last occasion.
Earlier.
Earlier also it's a part of record before this court. And this honorable court also subsequently directed to conduct an inquiry and hold the survey. That was also done, submitted in the last occasion, says that yes, the government has encroached our land.
There is no such report, my lord. I have already.
Sir,
submitted.
you have changed.
No, please
Earlier
say that
counsel.
is submission, the court will consider, you can make
But please
submission to the
kindly come
court.
to, kindly come to the survey dated, the survey report 3/7/2024. Before this honorable court, they have submitted.
Is it in Kannada?
It is in
That's
Kannada,
in Kannada.
but my learned friend knows Kannada.
But court do not know. Please file a translated copy of the.
Relevant reports.
The relevant part of the surveyor's report shall be translated and a copy of it shall be filed before the court when?
1 week.
1 week, post next week. Yes.
Cell number 14.
Date may be pending. After 2 weeks from date.
On 29. 29? This week, 29, yes.
Please.
Cell number 14. Telecast Gogi.
I appear the referent.
Yes.
Rahul S. Reddy.
What is the suit for?
Suit for declaration and injunction. Permit my notes, synopsis my notes for
Yes.
easy reference.
Please take that.
Answer other side.
Suit for declaration.
Please, my notes. Plaintiff's appeal before my notes. This is plaintiff's appeal. Against order 39 rule 1 and 2. Facts, my notes, if you could refer to my synopsis, my notes, I just taken brief, my notes. 7/2/1995, my notes, the defendant number 125, my notes. That is the respondents 125 are the owners, my notes, of the land, my notes. And joint development agreement was entered into in favor of respondent number 6, my notes. Where in joint development agreement, it was represented that land was converted by order of the deputy commissioner. And my lords, on 31/3/2009, Ganga and his children entered into a joint development agreement with the sixth defendant, sixth respondent herein. On same day, they executed registered power of attorney as well. My lords, may permit to take my lords a joint development agreement at annexure P, page 35.
Will complete your synopsis then.
Please, my lords, please, my lords. And my lords, under the said joint development, it is agreed that the developer's share is 90% and landowner share is 10%, and developer has also paid rupees 60 lakhs as a refundable security deposit by way of a check. And subsequently, my lords, another 40 lakhs was paid by check, my lord, that is the receipts are there, and rupees 2,50 lakhs in cash under separate receipt, my lords. Total, my lords, 3,50 lakhs has been paid, my lords.
No, defendant number 1 to 7 are the developer or the owner?
But 1 to 6 defendants before the trial court were my lords owner. Now here 1 to 5, my lords, because one defendant has died.
As they are arraigned before the trial.
Please, my lords. And seventh defendant before the trial court is my lords a developer.
by registered instrument of joint development agreement, my lords, a developer enter into a joint development, my lords, where the share of the developer is 90% and 10% is a share of a landowner's. And my lords, and in the said joint development agreement, owners represents that it is a converted land. Then, my lords, on 11/6/2009 and 10/6/2009 and 23/6/2009, total, my lords, 3 sale deeds are executed in favor of appellants in respect of B and C scheduled properties. There are total 6 sites, my lords, executed. And layout sketch was, my lords, is shown. When an attempt was made on 2013, my lords, to remove a boundaries, my lords, a suit came to be filed in OS number 625 of 2013 before, my lords, Principal Civil Judge and JMFC Devanalli for declaration.
The defendant, are they denying the sale transaction between you and them?
Now, my lord, they say that after 22 years, after 13 years, my lords.
When was this, sir? It was, you purchased a property when?
The joint development is of 2009, my lords.
No, your.
We purchased in 2009, my lords.
2009,
June 2009, my lords. March was a joint development agreement, my lords. We purchased in June, my lords.
No, that joint agreement, they will cancel in the year 2022.
Yes, my lords. Why, when interim order was in operation, when before the junior division.
No, what was their stand? All of them filed joint.
Today their stand is this: the developer from them, they borrowed a loan. As a security, they executed joint development agreement and power of attorney. Therefore, it was a fraudulent document. I am not bound by it. They never sought, my lords, a cancellation till 2022, my lords. And the fact of 2020.
What have you done with that land from that 13?
My lords, now, by superimposing, my lords, now what they've done, my lords, by cancelling joint development with the 6th respondent herein, they sold in 2022 with another third party, my lords, when injunction order was in operation. That person, my lords, by claiming under these landowners, having entered into a sale deal, now developing activities is taking on to superimpose, my lords, entire layout, my lords. And my understanding is given that, my lords, now what they are forming as a layout, my lords, even that is not approved.
Let's see.
Please, my lords. Now, my lords, coming to 6/8/2013.
No, developer and the landowners, they filed their respective written statements.
Developer has not appeared before this honorable, and not before the even trial court. Only landowners who have appeared, my lords.
No, he has got his share. No, he will not come. He has got his money.
Yes, my lords.
Let's see.
Now, then, my lords, what happens?
Come to the order. Once the court sees the order, there will be clarity of fact.
Please, my lords.
Then you can make your submission.
Please, my lords. Impugned order is at page number 22, my lords, annexure.
You find how much you purchased how much land?
My lords, I purchased total, my lords.
Each plot consists of how many square yards?
My lords, under 3 sale deed, 260/40, that is 2,400 square feet, 2 sites. And my lords, 1,200 square feet, 3 sites, my lords.
200?
1,200 square feet, 3 sites. That is 30/40, my lord, 3 sites, and 60/40, 2 sites. This is a Schedule A property is a larger extent, my lords. And Schedule B and C are my items referred by me, my lords.
Now, what did you do with that right from the day of purchase from 2009?
2009, my lords, there was a undergoing activities whether they have to supposed to, my lords, form, my lords, a drain and power. They formed a road, my lords, identified by fixed the boundary lines. I was waiting for, my lords, formally complete those drains, my lords. In 2013, my lord, there was an interference. Immediately, my lords, in 2013, I approached, my lords, junior division, my lords, filing a suit, wherein, my lords, ex parte interim order was granted in 2013 on 6/8/2013, my lord, which stood operated till my plaint was returned in 2023 December. That interim order was operating. They never choose to, my lords, getting vacated that. In fact, my lords, pending that, my lord, they makes a transaction where, my lord, they placed 2022 sale deed before this honorable court, even that reference is not made in the trial court. And my lords, when written plain, my lords, when I represented before senior division, by virtue of amendment, my lords, a pecuniary jurisdiction was changed. And I presented before my lords a senior division. Whereas senior division, my lords, they were kept in watch of the proceedings, and then they appeared. They filed objection in written statement. And learned single judge, learned trial judge, my lords, refused to grant an interim order, which was operating from 2013 by the virtue of the order of the junior division. And my lords, they cancels in 2022 with intent to annul entire all my lords sale deeds, where it is given understanding these my lords, there are 5 my lords under this proceeding sites. I heard my lord, there are 38 sites have been sold. 38 to 40 sites have been sold by the developer. And now by virtue of this cancellation deed, my lord, they want to nullify entire sale transactions. They admit a fact of execution of joint development agreement. They admit a fact of my lord, execution of a power of attorney. They only say that that was towards my lord's security.
Please come to the joint development agreement.
Please, my lords. Annexure B, my lords, at page 35 minutes. March 2009. Ganga is no more, my lords, his children are on record. Then in favor of Jai Chandra, 7 defendant. 6th respondent herein.
Page number 9. Whereas the above land is converted for residential use by the Special Deputy Commissioner, Bangalore, Urban District.
Please,
with order dated so and so.
Please, that is a landowner who represents me. Today they contended, the trial court go on that saying, purchaser be aware he has not verified. My lords, this defense is not available to my learned friends because they themselves represent in joint development agreement. Could they take this such defense today, saying that the trial court finding in that effect, my lords, is not correct, my lords? And kindly turn to, my lord, page number 45, my lords, where various check amounts have been referred to. Before that, my lords, in page number 44, last line, in consideration of foregoing, and the first party owner has permitted the second party developer to develop the scheduled property into residential layout by obtaining requisite prior approval, NOC permission, etc. from the competent authorities. The first party owner is entitled to 10% in the said developed layout, and the second party is entitled to 90% therein. The second party developer has paid to the first party owner interest-free refundable security deposit of rupees 60 lakhs in the following manner, my lord. They refer to 10 checks. My lord. Acknowledge, first party owner acknowledges the same. The first party owner shall pay to the tax, property tax in respect to scheduled property.
Please come to
Please,
the
ma'am.
written statement.
Written statement, please. In page 154 minutes, annexure M minutes. The address of the defendant number 236 above named for the purpose of service of notice process for this control of first tribunal. To declare prayer minutes, I leave it to skip para 2 minutes. I go to 3 minutes in the next page 155. It is submitted above suit is neither maintainable in law nor of facts, and the same is liable to be rejected in layman. The plaintiffs have no local standing to seek for prayer sought for at A as a plaintiff for total strangers to A scheduled property. And this defendant, being the absolute owner of schedule A property, are in peaceful possession and enjoyment of same from time immemorial. The amendments made at para 2 of the plaint, the defendant 126 herein, where the owners of 8 acres of land in survey number 80, Miskanahalli village, Chala Hubli, Bangalore.
This is unilaterally cancelled now.
Now, my lords, blow in hand. Now in 2022, when the interim order was in operation, they
No,
cancelled.
they say that the joint development agreement is cancelled. How it is cancelled?
Now that Jaychandra has gone and with the owners, they by registered
So
instrument.
now after selling the properties, now both of them will cancel it.
That is why, my lords, where there, my lord, this aspect of the matters. One aspect, my lords, this joint development of cancellation, though executed in 2022, has not been brought in before the trial court. Quite surprising. They today file it before this honorable court.
When was this written statement filed?
This written statement in 2023, my lords, on 21/12 to 2023. Page number 168, my lords.
168.
168, my lords. Date is there, my lords. Sorry, my lords.
That is your plaint, I think.
4124, my lords. 163.
When was the joint agreement cancelled?
They today, my lord, they place it before this honorable court on 21/12 to 2022.
21/12?
2022.
No whisper about this in the.
No, my lords. Nowhere in the written statement.
No, let us see.
Please.
What do they say about your, no, according to them, it is not, there is no joint development agreement, it's a fraud, it's so on, so forth.
They agree that there is a joint development executed, deed is executed.
Purpose is something else.
Purpose is something else.
Not to
For this.
develop it.
And they keep silent, my lords, up to 2022. That's, my lords, is a point for consideration. And, my lords, another aspect of the matter is they appeared in, my lords, in before the first court.
When was some sale deeds executed?
2009, my lords. In my favor.
Not your favor.
Among themselves, my lord. That's
later. No, you're referring to some sale deed.
That, my lords, same 21/12/2022, which they today produced along with the document, my lords. That is there in additional document which they have produced orders, application under 41 rule 27 before
Those
this.
parties were made as parties to the suit.
Purchaser, my lords. This purchaser I came to know subsequent to the suit, my lords.
No, I think you have to implement.
Now I do. My lords, what happens here is any act.
Now, what is the injunction you sought?
I sought, my lord, not to alienate and not to develop the property.
Yes. Yes, Mr. Senior.
Two cases are there, my lords. One is this for not to alienate, and another in the application is for not to interfere and carry out any development.
Yes.
And now one more contention, my lord, before my lord. They say that it is a larger extent. Court observes that how can I grant an A scheduled property? Obviously, my lords, I am entitled for that also because my property B and C scheduled property, in entire A scheduled property, roads flows. And if no interim order is
What is the
granted,
extent of entire A?
8 acres, my lords. 8 acres. I am entitled for all benefits which are assured under the joint development. I am entitled for that, my lords. Now they are superimposing.
No, 8 acres is the entire land.
Please,
you purchased this, it comes to how much of extent?
My lords, it comes around
if it is
around 10,000 to 11,000 square feet. My lord. I'll write a full complete. I'll furnish, my lord, but it comes around 11,000 square feet approximately.
Now, to safeguard your interest, why should the entire development be stalled?
That is because this reason, my lords. One is Now they're
So what has been provided to you by way of a joint, your sale deed, that should be retained.
That boundaries has to be retained because my sale deeds, that boundary has to be retained. And what may not assured under joint development that the development activities to be provided to me, they have to provide it. If that is not, because what happened is now today they are superimposing and changed the entire layout for plan, my lords. That, my lords, I lose, my lords. Where do I find my road? That is my concern, my lord. Therefore, my lord, this is my.
Yes, Mr. Singh.
Your lordship, this is the client, para 7.
Page number.
Page, I think wrongly mentioned in my
140.
paper book.
140.
In my paper book, 140 is there.
Yes, I've seen.
Para 7. Your lordship got it, no? That the plaintiffs have been in possession of the B and C schedule properties by putting up fencing around the same. About 1 month back, when the plaintiff visited the A schedule property, to their shock and surprise, it was found that not only the fencing put by the plaintiffs to B and C schedule properties was removed, but also the entire roads, drainages, and boundary stones put in A schedule property to market the sites have been totally removed by using a JCB, and the A schedule property was made look like a plain road. Your lordship can see when the sites are not in existence, then the question of granting of injunction does not arise. Then moreover, your lordship can see the prayer sought for. The entire 8 acres should not be developed. Then what happened? Your lordship can see this developer has made a cheating in respect of all the parties. Your lordship can see the development agreement. Who will give 90% share to him? 88 acres of land, 10% acre. Even according to them, your lordship can see that was converted.
Sign it. It's a registered document.
Yes, registered document. Your lordship can see they themselves, they are all agriculturists.
To cancel it or that.
No,
is
no,
not
it is
binding.
already cancelled by way of registered cancellation deed.
No, that is between you and the developer.
Yes, developer, your lordship can see what happened. Developer, as per the joint development, he has not done anything. Even he has not taken permission from the BIPA. He has not formed a layout. Without forming the layout, within 3 months from the joint date of the joint development, he sold the property in favor of that. Then thereafter, your lordship can see, he sold the entire property. That the developer has sold the entire property on 10/8/2011 in favor of R. Ramanathan under the agreement of sale. He received the entire amount and he sold the property, entered into agreement of sale, in respect of the entire property, including their site. Then thereafter, your lordship can see, he filed a suit for a specific performance against all these persons. That suit is pending. They themselves also filed a suit for injunction, this IA for injunction. That application came to be dismissed. Even they came to the High Court and application came to be dismissed. Then subsequently what happened, your lordship can see, the original owners have cancelled the joint development agreement because of this transaction.
How can unilaterally that be done?
Pardon?
How can you unilaterally do it?
That because your lordship, he has cheated, no, because of that reason, your lordship can cancel.
By way of a competent court, by way of.
By way of executing the registered cancellation deed, they have cancelled. But any of your lordship, then thereafter your lordship will say they sold the property in favor of one Venkatachalapati.
Is it permissible to?
It is not permissible. Joint development should be cancelled by way of filing of a suit only. In the meantime, your lordship, what happened? These plaintiffs, these defendants have sold the property in favor of one Venkatachalapati. Venkatachalapati, then he got the register of the property, and thereafter he formed a layout by obtaining the conversion order. He sold almost all sites, the layout.
No, at the, whatever that's happened.
Then even this 7th defendant, which Jaychandra, who is the developer, he has consented.
You are the owner of the property.
I am the owner of the property.
No, because of your acts being quiet and just looking at what is happening right from 2009 till 2022, unnecessarily, you made the people to purchase the properties.
No, your lordship can see what happened. Only obtained the joint development agreement without forming any layout. He entered into an agreement of sale.
Completely. When something is there and look at the joint development agreement, you said right now you can purchase.
Even your lordship can see the class 7 and 8 of the joint development.
That I have seen. And now the whole mistake is on your part, which made the people to purchase, believe it and purchase the property. You don't do anything right from 19.
But Lordship, even he has not developed the land, because of that reason
It is left to you to do, to say
yes,
that.
because of that reason, I don't know whether he has sold the property or not.
Oh, why can't you please come to the clause? You say.
Your Lordship, again, this is the class 7, this is page 9.
Okay, please, before that, please read clause number 6.
Which one?
To receive advance, page number 37.
Yes.
To receive advance, earnest money, deposits, part payments and balance payments relating to the developer's 90% and to execute sale deeds relating to the developer attorney's 90% undivided share in the property and the constructed area in the scheduled property. Not able to see page number 60, I think. There are 2 numbers on every page.
2 number
66. Clause number 6.
Clause number 6. The second party developer shall bear the entire expenses.
No, page number 5. That internal page number 5, it is
Internal
not, that is page number 5 of the agreement.
Internal page 5. In consideration of the form, last one, my lord.
To receive advances. No, please, if you find it, you show him. Counsel for the petitioner. Please. Clause number 6. I think it is starting from page number 50.
So that is power of
General
attorney.
power of attorney. That is
The
power of
GPA,
attorney.
Power of attorney.
Joint development agreement.
That is at page 60, my lord.
Yes, please show it to him.
GPA.
GPA clause.
GPA.
6.
Page 8, it is agreed that immediately after signature of this agreement,
Yes.
at liberty to enter into agreement with
Lordship
the
may-
prospective purchasers.
Your Lordship may kindly come to the page 4, internal page of the 4, my lord. Joint development agreement.
Yes.
Last one, whereas the scheduled property is located in an ideal locality and desirous of developing the said land to a residential layout, they have approached the second party with the said intention, and second party was engaged in the said field by making the following representation. Next, last one, my lord. In consideration of the foregoing, the first party has permitted the second developer to develop the scheduled property into a residential layout by obtaining the requisite prior approval, NOCs, permissions, etc. from the competent authorities. Then your Lordship can see the payment as shown. Then next page, my lord, page 7, class 7. The second party developer hereby undertakes to complete the formation of the layout within 18 months. Your Lordship can see he has undertaken to complete the layout in 18
That
months
is the problem between you and the.
without forming in a layout. That way even your roads are not formed.
Come to 8.
8. It is alleged that immediately after signing of this agreement, the second party shall be at liberty to enter into agreements with the prospective purchasers in respect of their 90% in the above layout. Your Lordship can see, because why it is a fraud document. Your Lordship, who can give?
You
Because
not questioned it. No, right from 2009 till now, so many third-party rights have accrued.
Yes.
You take the money from him with all these checks and all, you
Yes.
enjoy it. And now the developer will sell the property to third parties. And now you say you will unilaterally cancel it. What kind of a conduct on the part of defendant? It's out and out case to grant injunction.
Your Lordship can say, within developing the property, and you are the 8 acres of land owner. I am the owner of 8 acres of land. Who will give 90% of the share in that land? 10% I can entitle.
Nobody
Yeah,
tells.
that is because of that reason he created all those documents to obtain the
question it.
signatures. Yes, of course, your Lordship can see paid the amount.
No,
That-
2009 till 2022, why did you not question? It is my first question. Second
In
is,
the meantime, your Lordship,
Having
he sold the
cancelled it.
property even
No.
2011.
having cancelled it in 2022, why did you not tell it in your written statement in 2024? What are the bona fides on the part of?
24, your Lordship, I think that they have not stated in their written statement. But
did
anyhow,
you
they
not
have
state it?
produced the documents.
It's a
Even
very
I
important
produced the
document.
documents, all the documents before
This
this
is not
court.
in a written statement you filed before the court, you're supposed to say, no.
Well, even assuming that your Lordship can see where they will go. No, there is no
They don't
sites
do
at all.
Everything should be stalled unless and
Now,
until.
how
these
can
things
it
are
start?
decided.
Your Lordship is the person who has purchased the property, has obtained the BIPA permission, he obtained the layout plan, he has converted the land. These, all these stated in the agreement of sale, this development agreement on all forms. Even there was no conversion order at that time. Entire, this created by this seventh defendant only. He created the document and obtained the signature of these poor landowners and made a fraud. then your lordship is a
No,
developer.
landowners are not so poor, they have already. taken
Landowners,
some
you are
money.
not, your lordship, they are farmers.
No, look at it, where this amount has gone, is it your case that you have not received this money?
Allah, money your lordship, and say, as per this document, because he paid
How
the
much
checks
is
now,
that?
they
How
are
much is
60.
that? How much?
60,000, no
Pay
interest.
65 maybe.
That is 60 lakhs,
Pay
60
65
lakhs,
notes.
returnable amount.
But have you returned it?
No, your lordship against it, then thereafter he is executed in a confirmation date in respect of the other purchaser. He has paid the entire amount to him. Even according to them
developer-
only, your lordship can say, according to them only, the existence of sites are not there as per para 7 of their pleadings. When the existence of the sites are not there, how can they,
Don't alienate the property. Don't alienate the property, don't create third party.
which property, my lord, your lordship
Whatever
can
is the property.
like you there, after all, your lordship can say they have purchased 4 sites. Where is it?
Conduct.
Where is that?
What is the
Identity
conduct
of the
a
property is
defendant?
not proved.
My lord, this
Identity of the
same
property has to be proved by way of trial only. Your
They-
lordship against it, they themselves have said that there is no property at all, it is a plain land. How can go and does it? Your lordship, then thereafter, my lord, the purchaser, the subsequent purchaser, formed a layout and sold all the sites.
My lord,
If they want your lordship against it, they should negotiate with the subsequent purchaser and they will pay the amount.
They
Otherwise,
don't
your
have a
lordship
regards for
against-
court orders, my lord. They don't have a regards for court order.
That's
interim
what
order
is
was
evident
applied.
in all
Yes,
the
my lord.
transactions.
Yes, my lord.
Yeah, I have produced all the additional documents, your lordship, along with the application.
Not here, before, when you find your.
Before your lordship is there, they are not produced because of hurriedly they came and they obtained the order because
Written statement, what is hurry?
written statement that they have not made it clear that the entire thing has
That
not
is the whole
stated.
basis of your pleadings. Written statement is your pleading.
Please, ma'am. Like even your lordship can see if the court is granted an injunction or in favor of them, where they will go to the spot. They have no property at all.
No, you one round, the developer will sell.
Developer has only five sites.
One round, developer
Not the
will
entire
sell.
property was not.
One round, the landowner will sell. Third round, the
No, no.
developer from the landowner, another.
Only
second owner.
developer make all these things. Developer or lordship agency sell.
You will cancel it unilaterally in 2022.
Developer sold only 6 sites or 7 sites. Then thereafter he sold the entire property in
Now,
favor of some
in the
other
eye of
person.
law,
He
in the-
also filed in a suit.
In the eye of law, the joint agreement is still subsisting because you have no such power to cancel it.
That-
When it is there, why did you not seek for cancellation on the ground of fraud?
Allah,
That shows your
even
intention.
developer is accepted that the cancellation of the agreement, he put his signature. Then even he has executed the confirmation deed in respect.
Both of you will do different.
Confirmation deed. Confirmation deed in favor of Venkatachalapati who has purchased the property.
Yes.
Then your lordship can say when the property is not in existence, the court cannot supposed to grant the injunction. Because
There
there
is
is
a
no
side
identity of the property.
There is a side.
Even your lordship, if the suit itself is not maintainable. Suit itself is not maintainable. What is the relief sought by him? Your lordship can kindly see this relief.
Yes.
After all, if they are the purchasers of 4 up to 5 guntas, this is 8 acres of land. 8 acres. 8 acres of land means almost all 320 guntas. Here, your lordship, 5 guntas they have purchased. First, to declare the defendants 1 to 7 have no alienable rights in respect of the Asian property. How can they start for the entire 8 acres are not alienable rights? Defendant number 7 is not alienating the property now, or defendant number 1 to 6 are not
Why did
alienating
you
the
alienate the
property.
property after filing
Defend-
the written statement?
He is not a party. That the subsequent purchaser is not a party before the trial court.
He'll make them a party.
Let them make the party, my lord, then he will say, but then he will produce all those documents.
Nobody can play with the process of this like this. How can you do, what is this unilateral cancellation? What is this suppression of fact in the written statement? What is this says?
No suppression, because your lordship will see they washed away their hands by selling the property to some other person. Because of that reason, he is not a party to the proceedings. Even injunction is granted, that will not binding on that party because he has sold the property.
So till all these things are set at naught, don't sell it. Because that is itself now.
Already sold the properties and several sale deeds also produced along with these additional documents.
My lords, it binds him. It binds him also because he is claiming under the landowners.
Your lordship
Against
can
whom
say
the interim order-
Everybody
against whom
let
the interim order
everybody.
was operating.
Let everybody who is concerned with the land be made
I'll
parties to
make
this.
my notes. I'll make parties, but that doesn't.
Let them
mean
make
that
a party,
the
Lordship,
escape
the
on the
purchaser has bought,
contract.
and even all the way,
First of
almost
all,
all
the
the sites have been
landowner-
sold, let them make as a party.
I can understand a purchaser comes and tells all this, not the landowner cannot afford to say all this with all the conduct of the landowner.
Landowners, your Lordship will say, I already submitted that they are the poor, the farmers. They have,
Poor farmer will not unilaterally cancel a sale, joint development agreement of 2009 in 2022 and suppress it in 2024.
in the meantime, he has executed the agreement of sale. They themselves also filed a suit that is pending before the
No,
court.
he will collect all that from the landowner now for doing this.
Landowners will correct, the Lordship, the
They will
subsequent
do what
purchase.
he's supposed to do. No, he is not so like dumb that he'll keep quiet. Having executed another document. Oh, what is this? Some sanctity should be there to a
Right.
registered document.
Even your Lordship again say that is right. The developer has cheated by executing these sale deeds.
Both of you
Let
cheated
them,
him.
And both
your
of them
Lordship
can
can say, let them
execute
approach
cancellation.
the subsequent purchaser. I will advise him that he will pay the amount, return back the amount. Otherwise, he can't give the even sites because he has already sold the sites. Where is the sites? If the sites are there, then he will leave the site. There are no sites at all.
Let them produce a developed, approved layout plan before.
Yes,
this.
they will have
They're claiming that they have
all
sold
the
sites.
documents
We
which
are
are
not
produced
going
along with
into-
the additional
not going
documents.
into all those aspects.
Please, my lord.
What remains
Sorry.
here is you purchase a property, there was a joint agreement,
Yes,
which is still in the eye of law is existing.
existence.
So as far as your property is concerned, there should not be any third
Gail.
party rights.
In respect of which
My, all
property?
my rights, my lords,
Whatever
include.
property that is sold to him.
That is only for 5 sites. Then I can't stop my work in respect of the other property.
I have all benefits in the joint development, roads.
Whatever that is insured, whatever that is
The
insured.
what the joint develop, your Lordship can say what their vendor says. He has not appeared before the court. He sell the property to some other persons and washed
By
his
way of
hands.
joint development agreement, it is not alone him. You have
You
given
are
him the
also a
right to do
party
it.
because by what.
That is binding on you. We'll pass orders after lunch.
Your Lordship can kindly say that in respect of the Asian property, your Lordship cannot grant the injunction order because their side, let them grant in the injunction order, I have no problem. Your Lordship can say, how can they take possession of the land?
Defendant's conduct,
My lord, sincere.
defendant's conduct. And how many people are involved in this, we don't know.
No, only
How
four
many sales have
persons,
taken?
they have filed these suits.
What is happening, how series of litigations will go on like this? Hmm. 14/8. Then call the registry, what is happening from 14/8 till now? Why? So, it has been collected wrong back.
My lords, in serial number 13, there was an interim order.
No
after
adjournments.
Court officer?
Previous days submit ಮಾಡಿದ್ದಾರೆ. ಅದು ಎಲ್ಲಾರ್ಗೂ ಗೊತ್ತಿಲ್ಲ, ಅದು ನಮ್ಗೂನು ಅದು ಗೊತ್ತಿಲ್ಲ.
Court officer? Camera on ಮಾಡ್ಲ.
ಸರ್ ನಿಮ್ದು ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ ಜಯಪ್ರಕಾಶ್ ರಾವ್ ಸರ್, ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಡೆಯುವಾಗ ನೀವು ನಿಮ್ದು ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್, ಅದರ್ವೈಸ್ ಇಟ್ ವಿಲ್ ಬಿ ಡಿಸ್ಟರ್ಬಿಂಗ್ ದಿ ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
27 ಅರ್ಜೆಂಟ್ ಆಗಿಲ್ಲ ಮೇಡಮ್ ಅಲ್ಲ?
ಸರ್
27 ಅರ್ಜೆಂಟ್ ಆಗಿಲ್ಲಲ್ಲ? 27 serial 27
27 is there, I think. Wait sir,
ಅರ್ಜೆಂಟ್ ಆಗಿಲ್ಲಲ್ಲ?
it is not yet reached. 27 is there in the list.
Thank you. Court officer 35 ಹಾಗೇನಾ?
ಸರ್
35 ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ?
35
Ah,
35 is also there in the list.
okay, okay. Thank you.
Tomorrow is the first matter.
Yes, ma'am.
A request for day after tomorrow. Some-
Day after tomorrow, first
Please,
matter.
some inconvenience.
At the request of the counsel for the respondent. Yes.
Cell number 15. 15 urgent, cell number 16. Shivacharan R,
Yes, it is for the appellant.
Tabal Hussain,
Asif, may kindly recollect. In the last occasion.
It's a matter where, my lords, the issue of
Occupied-
corrupt practice.
Directly trans- it is
Why is,
not-
for the translation, it is adjourned.
Yes, yes. That's I,
My lord, what we have
Also
done,
have
my
to
lord.
translate.
no, no, I just want to, I've not seen what my friend has given, but I just thought I did not feel. So,
Same here, even you had not served. Anyway, Lord, what we have done here is, my lord, at page 2, word to word we have translated.
Submission past 6 months period.
No, word to word we have translated, my lord. And thereafter, entire paragraph has also been translated
perfect,
for better understanding.
perfect. That's exactly what we have done.
Details of cases. It's filed by whom? It's filed by,
That's by the petitioner.
Along with the memo, my lord,
either details of cases where either charge sheet has been filed or charges are being leveled,
Leveled.
framed to the honorable court as regards offences that incur punishment of imprisonment of 2 or more or a period of the past 6 months prior to date of filing of this nomination.
So, my lords, if my lords may look at the English version, word to word, what he has translated. The same thing. It goes on to say, the last 3 lines might be important. My lords, during imprisonment, sentencing offences regarding upon me from the court, charge sheet or allegation, it's not charge, my lords. The word which is used is, if my lords may turn to my memo, what I have done is I have produced the Kannada and I've produced the transliteration of the exact word in English, so that my lords, it becomes easier for us to read. So that's my Kannada version, my lords, the last 2 lines. Here, my transliteration, my lords, in Athava Apadane. My lords, Apadane, it is not his meaning of saying allegation and charge. If my lords, allegation can never be a charge. It can either be a charge or it can be an allegation. Now, once it's
we read word by word.
no, no,
Then, my lord. let
no, no,
me-
1 second,
my
sir.
appeal- Let me make my submission first.
That's in my own paper, in the document which I've given, in the middle quadrant, which is transliteration, my lords, above the word Athava, it is Nyayalaya Dinda, Dosharopane, meaning Dosha, my lords, charge, Aropane, meaning you need to prove your charge, framing of charges is Dosharopane.
Please, ma'am. May I read, my lord? Word to word,
No, prastuta, that is present.
present, yes.
Yes,
Namapatra, that is
Nomination.
nomination.
Sallike,
Salike,
Salikeya is submissions.
yes, ma'am.
Indina means
Past,
past
Aru, 6.
months.
Tingalu means, my lord, it's months.
Past 6
Avadigalu.
months.
Yes.
Avadiyali means
Avadi means months. Oh, sorry, period.
in the last 6
Period.
months period. Avadiyali means
6
period.
months.
Yes, yes.
6 months period.
Next,
Then,
Eradu Varsha,
causing
2
that,
years, 2 years.
Then
Dondu, correct,
Varsha.
Erdu Varsha.
Athava.
Eradu Varsha, rendu.
Erdu Varsha, Athava, Hechina.
Hechina, meaning,
No, again, like, we'll stop
Please,
here.
let me read this.
Ah.
Memo, I have filed, I have the
yes,
one who
ma'am is
translated.
reading my
My
document.
memo, my memo.
Ah.
Filed by the appellant. here. Please, 5 minutes. Yes, my lord.
For here, till here I understood. 2, I mean,
Up to, my lord,
Varsha,
2 years, 2
Varsha,
years. Yes.
Athava,
Athava, Echina. Echina means, my lord, in excess.
in excess.
In excess. Next is Avadige, duration.
Avadiga is duration.
Yes,
Ah,
ma'am. Karya Gruha Vasada means imprisonment.
ah,
Sikshe, sentencing.
ah,
Vidusala Bahudada, offenses.
ah.
No. Vidhisabhaudada meaning it can be imposed upon 2 years or more. Jail term to be imposed upon.
Ah,
Aparadagala,
Means, my lord, it is offenses.
ah.
Bagge regarding upon me, that is Nanna, mele, upon me, my lord. My lord, this is the,
Look at it, what it says is, in any of the cases, a charge sheet is filed against you for the offenses where the imprisonment is below or exceeding 2 week or some, what is that?
2 years, 2 years.
Exceeding 2
2
years.
years.
What are the details?
May
of
may
those?
make the submission. It's just not charge sheet. It is dosharapane athava. Athava meaning or.
My lord, the focal point here is,
No, no,
my
the
lord,
focal
only one,
point is
one,
not,
one
it is,
word, my lord.
it is
That
apadane, my lord, said the government.
Nyayalaya, means before the court.
As
My lord,
of
now the court cannot register the FIR.
As of now, I am understanding it as you understanding it.
Please.
So let us hear him.
Yes.
Yes.
That's my understanding, that's of Kannada, what I know. That's Nyayaladinda. There are two things which are mentioned in paragraph number 7. One is dosharapani, which is charges being framed. That is number 1. Second, or athava, apadane. For us, see
Where are you getting this?
the word apadane.
Where is that?
That's no, no.
What is Lagiruva?
1 second, sir.
Look at it at your translation.
In my transliteration,
Read
that's
again, prastuta.
prastuta,
Nama
namapatra sarikeya hindane.
Just pause there. You please tell the court what is that?
That's in the present nomination form. Why hindane from the date?
It is.
No, hindane meaning from the date on which I am filing this.
Past, Hindana is
Aru
past.
Tingala avadiyalli, meaning in the last 6 months time. That is, I need to read Hindane's 6 and Tingala avadiyalli. Yaradu varsha athava ಹೆಚ್ಚಿನ avadiya karagruhavada sikshe. From 2 to sikshe. That's essentially means any offense which is imprisonable for 2 years or more. Vidis about.
To charges and charge sheets.
Yes, that's what I'm coming down to. Bagge, my lords have with both of us till Bagge Nanna Mere. Till there, I think my lords both of us agree upon it. Now the next 4 lines, Nyayalaya Dinda, Dosha Aropane, meaning framing of charges. Next word, Athava.
What I understood is, it refers to 2 contests. One is framing of charges, filing of charge sheet. Not filing of complaint. Where do you get that filing of complaint?
Yes, my lords. Filing of a charge sheet, my lords, would be not the court. Charge sheet, my lords.
That is charges. Charge sheet was a charge sheet.
Charge sheet, my lords, will be filed by
Prosecution.
filed by the
Charges
prosecution,
by the
submitted. Subsequent to which the stage is framing of charges.
Yes.
Now, my lords, before that, it is only charge or the allegations which are in question. Now,
Will not be at the stage of FIR.
that's this precisely my argument is the words which are used are
This charge sheet is filed
No, my lord.
as
No,
of today it's filed.
Not a,
as on today.
That day,
As on
it was
that
just
day.
2 weeks prior to my lord dating.
As we'll
Yes,
ask him.
please.
that's I would as on that day it was not. No.
So as per this particular clause and translation, it speaks about two things. One is about the 6 months period, from the last 6 months period, 2 years imprisonment, then 2 years imprisonment, offenses punishable with 2 years imprisonment.
2 years or
more. Where the charge sheet is filed or where the charges are framed.
No, my lords. That's what I'm trying to say, my lords. The dosha Nyayalayadinda dosharopane, meaning the framing of charges, my lords.
That is Nyayala.
Yeah.
Yes.
Athava,
Or
apadane, allegations or averments. Horasidu, D0 Gali, Prakaranagara.
Lagiruva.
Okay.
charge sheet.
No. Well, that cannot be the word charge sheet. That's the next word.
If it is not charge sheet, Aropana Patra.
Yeah, you have to read in entirety, not.
That's apadane. That's aropana is not. It's not preceded by the word patra. It goes on to say prakarnagala vivaragalu, meaning the details of the complaint. The details of the complaint is what is important.
Now,
Apadane is a word.
looking at this, No, it should be something like what the, like on the last occasion, whatever the arguments that transpired in the court, it was like the nomination form says, any cases, registered criminal cases registered against you. In that case, he has to disclose everything. No, such a simple and straight question is not here.
No, that's, that's the reason I'm explaining, my lords,
That
in
it
the
says
affidavit.
about, no, in that case, then we have to look at the People Representatives Act and the subsequent judgments.
And I did so. I did refer to my lords with regard to it. In fact, my lords, one clarification I have to place on record. In the affidavit, my lords, there's column number 5 or the point number 5, point number 6, point number 7. Point number 5 is where he's convicted. Now, my lords, where he's undergoing imprisonment. Point number 6 is where he has been either acquitted or discharged. Point number 7 is a point where he discloses his criminal antecedents, or my lords, if this word is too big, any kind of an allegation which is attached to either of the IPC or any other acts which indicate him.
From this, where is such a long definition?
No, my lords, I'm only relying upon 4 words. Athava,
No, word to word translation, what he has given. Please look at that.
no, my lords,
Is
it
it
can't
correct or
be.
not?
My lords, let's go by his thing. my lords.
Present nomination,
That's
submission.
present nomination regarding upon me,
Huh.
last 2 lines, my lords, for my reading
Sentencing.
again. From the court,
From the
charge
court.
sheet upon me from the court, or allegation revealing cases details as under. My lords, he uses the word,
Charge.
no, that's
From
what
the
he's
court.
saying. It
From
is
the
not the
court.
case, sir. Sir, where's the word from the court? My lords, what?
Nyayalaya.
That's what he, it's a disjunctive word. All is a disjunctive word. We can, when the word is being used as all, my lords, it can, that's my only request is that, my lords, on this small issue, my lords, it can, I don't want the matter to go either his way or my way. I request my lords that, my lords, let anybody from the government side, my lords, make statement with regard to translation. Let them make a statement that, yes, it is only pertaining to a charge sheet, my lords. Then I would definitely bow my head and I have no case before my lords.
Lord, may I make one submission?
And in any
But
event,
the
that was not his
affidavit-
contention before the trial court at all. Not even once he has taken this contention.
My lord, the affidavit clearly states that from Nyayalaya. Nyayalaya means any court, my lord.
No, where does it say?
You can't read out the Kannada version.
Counsel,
My lord.
please look at that, give it to him, that 7. Please read it and what is it? Tell the court.
ಪ್ರಸ್ತುತ ನಾಮಪತ್ರ ಸಲ್ಲಿಕೆಯ ಇಂದಿನ 6 ತಿಂಗಳ ಅವಧಿಯಲ್ಲಿ 2 ವರ್ಷ ಅಥವಾ ಹೆಚ್ಚಿನ ಅವಧಿಗೆ ಕಾರಾಗೃಹವಾಸದ ಶಿಕ್ಷೆ ವಿಧಿಸಬಹುದಾದ ಅಪರಾಧಗಳ ಬಗ್ಗೆ ನನ್ನ ಮೇಲೆ ನ್ಯಾಯಾಲಯದಿಂದ ದೋಷಾರೋಪಣೆ ಅಥವಾ ಆಪಾದನೆ ಹೊರಡಿಸಲಾಗಿರುವ ಪ್ರಕರಣಗಳ ವಿವರಗಳು ಈ ಕೆಳಕಂಡಂತಿವೆ.
What does it mean?
This is the meaning, Lord. The following cases.
Here the point is, does it say that any cases that are registered against him shall be specified, or any cases where from the last 6 months, imprisonment which may exceed 2 years or more, where charges are framed by the court, where the charge sheet is filed? Is it so? Or it says about or any offense that is registered against you, any crime that is registered against you shall be furnished.
Here stated that, Lord, any offense punishable under imprisonment for more 2 years and more than 2 years. Before 6 months. Before 6 months. And Lord, ದೋಷಾರೋಪಣೆ ಮತ್ತು ಆಪಾದನೆ ಹೊರಡಿಸಲಾಗಿರುವ charge and charge sheet filed in the following cases. Like that it is stated.
My lord, if the form. Correct, yes.
With the-
My lord, second line,
Who has translated this?
Lord,
Like, the file that, from a translator.
please, my lord, and also with the Kannada version of that.
Kannada version,
CRPC.
Kannada thing in English.
Yes, ma'am.
And then
Kannada
what is
CRPC,
exact
Lord, yes,
meaning
yes,
of it,
yes.
that they let it be from a translator.
Please, my lord, here,
Certificate also.
Hmm?
Let it be with a certificate of translator.
Hmm.
Lord, here,
It should be.
second line, my
Who
lord. in
will
the-
ask the registry?
That's, I think that would be.
Huh?
The registry might be in a position to do it, to aid my lords.
That's what I'm saying.
Yes, yes.
The registry is directed to translate this,
Exhibit P2.
exhibit
Combination
P2/19, clause number 7. Post this matter day after tomorrow, on next Monday we'll see.
Great for me.
Lord, Tuesday, my lord. Monday.
7.
Huh?
Tuesday, can you have?
Tuesday.
Okay.
Tuesday.
Monday is a holiday.
Tuesday. Yes. Hmm. Yes,
Cell number 17 again, cell number 18. Topic 10 Chetty. 18.
Yes.
For the appellant in this matter. Bill under section 37 of the Arbitration and Conciliation Act.
Hmm.
Matter, my lord, that property belongs to respondent number 1 was acquired for the formation of National Highway number 66. Appeal is by the NHA. And accordingly, respondent number 2 decided a compensation. The acquisition is in the year 2015. Preliminary notification 7/4/2015 and final notification 2016. As per section 3.
What is the order impugned now?
Order. Page number.
The arbitration petition filed with the petitioner.
Yes,
So and so is
page
hereby
number 13.
rejected.
Compensation decided by the.
Arbitration award passed with respondent number 3 dated is hereby confirmed.
Yes, ma'am.
You are the claimant,
I am the authority,
you are
National.
the National Highways Authority. Similar matters are coming up, so many matters in the oral pertaining to one
Yeah,
acquisition.
almost similar matter, like, different areas are there. This is pertaining to Mangalore to Udupi, National Highway 66. Similar
Well,
matter.
let us see, come to the arbitrators award.
Lordship may kindly see. Page number 29, Mal.
Yes.
Yes, before that, I would like to make one point. Here, respondent number 2, he is the competent authority and to pass general award. He is also state government employee. Since they are well aware of the revenue matter, central government, as per the act, they are appointing respondent number 2 as the deciding authority for the compensation amount. He has to pass general award, but in entire villages. In this matter, property of the respondent number 2 is acquired, portion only 3 cents. 100 cents means 1 acre, my lord. 3 cents of the land acquired, 121 square meters. And accordingly, competent authority, respondent number 2, decided a compensation of rupees 19,428%. That means around 19 lakhs. After that.
Before that, if we come to the order, then I'll understand what it is. Come to page 31.
Yes, my lord. Lordship may kindly see relevant portion is perused with the last paragraph, my lord. May I read, my lord? On verification of the document, it is found that in this case, notification under section 3 of the National Highways Act 56 was published on 7/4/2015. 3G notification issued on 29/1/2016. 3G award issued on 7/12/2016 and award notice issued on 19/12/2016. The respondent number 2, as per the above said notification, dated 19/12/2016, acquired the land in this case in Natsal village in respect of the land held by the applicant for widening of Kundapur Surutkal section of road NH 66 under section 3 G1 of the National Highways Act 1956 and awarded an amount of rupees 19,428% at the rate of dry land. Accordingly, respondent number 2 determined
According to you, what is wrong with the order
in this matter, my lord.
of the arbitrator?
Yes, according to me, my lord, during the acquisition, based on the revenue record, shows that it is only dry land, not converted land. But arbitrator enhanced the compensation thinking that it's the converted land.
At point number 3, page number 32.
Page number 32. Yes,
Point number 2.
yes, that is under challenge.
The appellant requests to enhance the compensation amount at the rate of converted land as this land is converted for non-residential purpose before the date of 3A notification.
Yes, ma'am.
According to you, it is not correct.
Yes. Then he
Where did
decided
you say so before the court
trial,
that that is not done?
trial court. Page number 15, paragraph 5.
Para 15, page 19.
Page number 15.
No, come to page 19, para number 15.
Paragraph. This is good. This court is of the opinion that the content respondent number before the arbitrator respondent number 3 learner arbitrator is that one before issuance of preliminary notification dated 7/4/2015, he had converted the property for non-agriculture purpose for commercial purpose. Filed conversion order dated 15/6/2010, passed by the Tahsildar Udupi in reference number so and so. In view of the conversion of the agriculture property into commercial property in the year 2010 itself, by the respondent number 1, the acquired land property has lost its character of being very agricultural land. Here, important point here, Lordship may kindly see. There is no commercial activity. There is no construction. We have acquired the property, vacant land.
No, they say that's the only crux of the issue is this. According to the arbitrator, or according to the
A
court,
converted land.
it is a converted. What did you place before the court to say it
Yeah,
is
one
not a
document here
converted
could be
land?
converted in the year 2010.
And then,
But here is, not only that, 1,95,000 was not the amount during that relevant period. He has taken when
so
passing
from the order, let us see what is your contention before the court.
Yes, my lord. Further, this court is of the considered opinion that, for the respondent number 2, while assessing the market value property, had taken to consider acquired land as dry land and relying the sales statistics of the previous 3 years, had determined the market value property of the respondent number 2 at 19,428%, inclusive of solatium and other statutory benefits. But as on the date of preliminary notification, as already discussed above, the acquired land was already converted as commercial land, which fetches more market value. He has to decide, arbitrator, based on the 3 years prior. He has not given any reasoning. What was the exact value?
No, ultimately, the difficulty is you people just like that contest something
Yes, my
and
lord.
some order is passed and come again to the High Court.
Yes.
Just like that, now these MFA will see the
Yeah,
light
one
of the
more
day
point.
after 10 years.
Apart from that, one more legal point is.
At least let us see your grounds. What are your
No,
grounds?
one more point, my lord. In this pattern, not on that giving any amount to the landlord because it's a compulsory acquisition. Here, what has happened, my lord? 2016, 3D preliminary notification, 2015.
No. First, please show to the court, what are the grounds urged by you before the before the court?
My main point is,
So you should have said
no,
it before the
legal
court.
point, legal point before the trial court is
Yes.
the claim application under section 3G5 of the Arbitration Act and NH Act filed before the arbitrator by the claimant, that is respondent number 1, here is time bar. Because
Where did you take such a ground? Before the arbitrator, before the court,
before the court I have mentioned.
not this court, before the
Before
court,
that court.
before the trial court, before the arbitrator.
Petition copy, my lord, page number 18,
Hmm.
barred by limitation. Can you see?
Not before this court.
But he has not
The
given,
trial
before
court.
the trial court.
Hmm.
Paragraph number 18 is one of the contention there. The honorable arbitrator failed to consider the application filed by the defendant number 1 is barred by limitation. Here, point is that, my lord, There is no specific limitation prescribed under the Act for filing application under 3G5 before the arbitrator. This honorable court held that,
Ultimately, you've taken their land.
yes, ma'am.
They're
then-
entitled. Don't come with these kind of technicalities.
Yes,
It's not
ma'am. Yes,
inordinate.
I do accept. Moreover, one thing.
And
ma'am,
no, even for this also, no, where did you say? That I want to see, be either of the court saying that this is how it is, this is not, this is the market
Point is,
value.
my lord, here, whether he has filed that application within 3 years or not, for that matter, Supreme Court also, on matter is pending, is still not decided. For that ground, they are giving us to file appeal. Even my opinion also, since they are the landlords, I have that copy of my opinion also, accept that award.
When was that? When did they accept the money from you?
Award dated 2016,
Hmm,
26/9/2016.
hmm.
And notice of award dated 19/12/2016. Then appeal filed before the arbitrator on 3/8/2020, that is after limitation period. For that, should me kindly see, our division bench of this honorable court held that Article 137 applicable where the limitation is not prescribed under the Act. Should me kindly see.
That's a general law, wherever when there is no limitation, residuary clause.
137 applicable. That matter is pending before the Supreme Court. Only on that ground it is pending. Moreover, Lordship may kindly see, direct me to deposit certain amount. Lordship me,
Where do you get the date? When did they file the appeal?
pardon my lord.
When did they file the appeal? Where did you get that?
Appeal filed on 3/8/2020, my lord. After lapse of 3 years and 5 months. 3/8/2020. Similar matter came up before lordship also. At 50% subject. to
75%. I remember that.
No, no,
Please
my
come.
matter. 50% only.
No, it's 75%. 75% in similar orders.
Yes. Court even
No, this court has granted 75%.
give 2 orders of this honorable court, division bench and.
No, this court has passed. This court has passed. This is interim order is a discretionary relief of the court.
Maybe some other advocate.
It's an agreed with the order passed, agreed with the order passed in the arbitration petition number 2 of 2023, date 22nd April 2024. The National Highways Authority is before this court. It is a case that the award was passed on 26/9/2016 and on 19/12/2016, an award notice was given and the present and the parties have filed a application before the arbitrator on 3/8/2020, which is barred by limitation. It is submitted that in similar matters, the stay was granted by a coordinate bench of this court on the condition that 50% of the amount has to be deposited. This court had passed orders where the stay was granted on the condition of depositing 75% of the deposited amount in the other matters. In that view of the matter, there shall be stay of all further proceedings on the condition that the appellant shall deposit 75% of the award 75% of the amount determined by the arbitrator within a period of 6 weeks from the date of receipt of the copy of the order, notice to the respondents
For the executing court.
before the executing court.
Till number 19. For appellant,
Waiting for the petitioner, my lord. My lord, this matter is reached this honorable court after the civil court in Devanali refused to grant an interim ex parte injunction. My lord, the impugned order is at Annexure A, page number 49, my lord.
What is the suit for?
My lord, it's an arbitration application under section 9,
Oh,
seeking to restrain the respondents
Hmm.
from alienating the properties.
that was not granted.
No, my lord, not granted.
Come to the order.
Yes, my lord. My lord, Annexure A, page number 49.
Yeah.
My lord, the order reads as the fourth line onwards, she agreed to purchase them and booked 21 plots. My lord, that is incorrect. In fact, my lord, I have booked 5 plots, varying from plot number 17 to plot number 21. My lord, that's the first error, my lord. Secondly, my lord, this amount on the last,
Come to your application. Where is the application?
my lord, page number 51.
No, interim application.
My lord, on, for this court.
No, here. IA number 1 to 4, 5, where are they?
Yes, my lord. My lord, they're at page number, at the end, my lord, they've been annexed. My lord, 391 onwards till 440, my lord.
Three?
399, 391.
Not here. For the trial court.
My
So
lord.
file the IAS.
Yes, my lord, they've been filed.
application.
My lord, page number 121.
One 21.
Yes, my lord. Till 153, my lord.
Got a order of ad interim temporary injunction restraining the respondents from selling, disposing, or creating third-party rights respect to the Schedule B property. And then what is the other applications?
My lord, in fact, Schedule A is the larger property. In Schedule A, my lord, I have purchased 5 plots. Therefore, my lord, I am seeking to cancel all 5 agreement to sales. Henceforth, my lord, we filed 5 IAs, each IA for 1 plot. Therefore, my lord, IA number 1 is for Schedule B, IA number 2 is for Schedule C, and henceforth, my lord.
Similar applications for different schedule properties.
Yes, my lord. My lord, if I could make one submission, the entire dispute is regarding the cancellation. My lord, if my lord could come to page,
Let me just read the affidavit so that the facts will be clear.
yes,
So you paid 6,000 and 160,000 for booking the plots.
my lord, yes, my lord, I paid 60,000 per plot.
60,000 per one, and for the remaining 6,000.
No, my lord, I have paid for the 6,000, my lord, is over a series of,
3,001, 1, 2, 60, 3, 4.
all 5 I paid 60.
Hmm.
My lord, in fact, over the entire 1 year, I have paid a total of 81
What
lakhs.
is the rate of the plot?
My lord, it was 3,200 rupees per square foot in
So
May.
how many square foot?
My lord, it's varied, my lord, but if you take Schedule B is 1200 square foot.
So it comes to how much?
It comes around 38 to 40 lakhs, my lord.
So 40 lakhs, you paid 60,000.
Yes, my lord.
Hmm.
My lord, at the beginning, my lord. Subsequently, I have made 40% of the payment per plot. All the receipts have been annexed, my lord.
Take a merchant notice to the respondent.
My lord, one submission, my lord. If my lord could come to page 370, my lord, it is their note, their reply to our notice, my lord, in which they have agreed to receiving the amount of 80 lakhs 51,000 in their reply notice.
No, take a merchant notice for a response.
My lord, if they alienate the property, my lord,
No, with
My
all
lord, I
this,
have an
no, with all this agreement of sale and all.
I have an agreement for sale with the respondent, my lord.
We'll hear them and pass orders. Issue emergent notice, post this matter on, 2nd of September.
So, like,
Yes, next.
Cell number 20 adjourned, 21, Sri Krishna Gowda for expel. Vedamurthy, sir.
No representation for both the parties. Post this matter, 15th of October. Yes.
Cell number 22,
Yes, my lords, I am for the respondents.
Sita Devi Limited.
Yes.
For the petition.
Yes.
No, this is the petition filed against the order of the trial court granting the family court Mysore granting maintenance to the wife and the child. Now, the court has awarded 9,000 for the wife and 6,000 for the child. Two grounds that we have raised, my lord, is that admittedly he does not have a job. And he is an agriculturalist. He does not have a job. And he is dependent on the agricultural income only. So now, right now, his parents are what his mother is supporting him to pay this maintenance. And he's not having a good health.
What is age?
But he's now about 43, 44.
Yes.
But he's counting days. He has liver sclerosis. So that is the issue that is there, my lord. And because of that, he's he's not able to get any job or even go for a job. So
What did he
this,
pay till now?
he is now paying as per the court directions, my lord. 10,000 was directed to be paid, and we are paying that money, my lord, as per the interim order. As per the
Mr.
interim
Counsel,
order,
what do you say?
6 plus 4. That's the amount that is being paid as of now.
For the respondent.
My lords, please, my lords. I have been instructed that there is arrears of about 3 lakhs, my lord.
So what is his income and she
My
says
lords,
that,
this is second
he's an
round of litigation. The same grounds were urged before this honorable court where a writ petition came to be filed based on the interim order passed by the same honorable family court, my lords. This is second round of litigation. Same grounds were urged by this by the petitioner, my lords, and this honorable court, a coordinate bench of this honorable court has already addressed it. In fact, they have not produced to that effect, my lords. He is suffering from many liver diseases. It is not on record. He himself gets examined before the trial court and he has not
Please
placed
start.
on record.
Place that about his health condition.
I'll place it on record.
And counsel for the petitioner submits that the petition is suffering with liver cirrhosis. And she'll come up with the necessary documents in that regard. Pose this matter after 2 weeks on 3rd of September.
Very well, great.
Yes, next.
Preliminary hearing group 23. Keshav,
Kindly pass over the matter. Senior is withheld in some other court.
May I request for an adjournment?
My
Day
lord, we
after.
have moved the matter. Kindly, senior is.
Let us see what is their urgency. Yes.
Till number 24. Purti Hegde.
Works for the petitioner, my lords. The last date of hearing, my lords, this one of court sought for the clarification from the second additional family court, my lords.
Yes. Give that.
Ladyship, I would be happy to assist the court in case any thought comes about this purchase, Your Honor. Any thought about this purchase, if it comes in the mind of the court, I would be happy to assist the court, my lord. Not only that matter got transferred and it has proceeded so much that they made a statement on this Saturday, they are going to close the cross-examination, which we are not seeing for last more than 17 dates of hearing.
What, like, wherever the lower court is referring, petitioner is who?
I was the petitioner, I am the petitioner in the family court.
2021, the petitioner was present, the counsel for the petitioner has a filed adjournment application and submitted the WP number 6372 is pending. Hence, the matter was posted to 5/3/2024 for further cross-examination of petitioner. On 5/3/2024 and on 6/3/2024, the petitioner was absent. Hence, the matter was posted for further cross-examination.
Well, there are two petitions. In one matter, they are the petitioner, and in the main divorce proceeding, I am the petitioner.
It is, they are referring to the divorce proceeding. They will not refer to the interlocutory proceeding.
Both are clubbed together as per the order of this.
No. Interim maintenance also in that also they will refer as they are like a petition respondent only. They'll not again say that in maintenance matter you are petitioner, she is petitioner, and in main matter you are
Yes.
petitioner. On 4/6/2024, the learned counsel for the petitioner has made allegations in writing against the presiding officer regarding the manner in which the matter is being conducted. Hence, this court has directed the office to place the entire record before the learned principal family judge to transfer the case to some other court. On 14/6/2024, petitioner was absent. Advocate for petitioner has again made allegations against the court in writing.
Well, because the matter was directed to be transferred, ma'am.
Court has not received any orders from honorable
Yes.
principal judge. The matter was posted to 21/6. The learned counsel of the petitioner has made multiple allegations against the court and submitted that the petitioner does not feel that the atmosphere is conducive for conducting the matter.
I can take the court through all the pursuits which are filed by me to satisfy the court, my lord, what was happening in the court, trial court. And these are visible changes after getting the matter transferred. I take the court through all the material what was there before the trial court. We come from Bombay, trial cross-examination is
That is not the problem of the court if you come every
No,
time.
no,
from
not
Bombay.
an issue. I'm trying to highlight something else, my lord. Trial is conducted for 20 minutes, 30 minutes. We go on requesting the court that we are available, whatever time court says, I'm willing to work from 4:30 to 6:30 as per the convenience of the court. I placed the,
First of all, whatever the opportunity that is given to you by the court is out of the way. The court cannot say that what is so exceptional about this case?
no exception, nothing
That
exceptional.
case court has permitted you
Yes,
to
my lord.
conduct the cross-examination.
17
And why
times.
for again and again insisting for these kind of things? Let's see.
Yes.
17 times I come from Bombay just to face the cross-exam.
Did that under great compulsion, this being filed on record so as to bring on record the conduct of the presiding officer as well as the conduct of the advocate for the respondent, which are these two elements, does not feel that the atmosphere is conducive for conducting the matter. If every litigant starts these kind of letters, is it possible to conduct proceedings?
May I just point out few circumstances, my lord? I wrote this Persis after a long gap of 16 dates of hearing, my lord.
16 days is not a long time.
No, 16 for the purpose of cross-examination. The gentleman comes, not every time, my lord.
Every litigant who is not happy and who
Is
is
not-
not like the judicial officer is not taking up the case as per his
No, not at all.
convenience, huh?
We are
You
available.
can't make allegations. What is a big reason for the judicial officer to act detrimental to your client's interest?
There's no, my lord, I should not say, but there's a style of working. Now since the matter has been transferred,
If it is her style of working or his style of
we
working,
adjusted.
for yourself, wherever, whichever court's working style is.
No,
like
not at
it,
all.
that
Not
can't
like-
be- It can't be
Not-
transferred there.
Let me take the court through all the Persis which I filed. I knew these things will come up, therefore at every stage we would be filing something what was noticeable. That has never been denied by anybody. What transpired in the court now, after getting the matter transferred, on 3 dates of hearing, cross-examination has been conducted. And on this Saturday, they made a statement that they will be closing the cross-examination. This is the movement. But what do I do? We have cooperated to the maximum possible extent. Even before this court, we have been coming, no difficult, we are bound to come. Just that, my lord, we are taken for a ride. We come, we do, cross is not completed.
Both of you taken the system for a ride.
My lord, apart from appearing and conducting the matter, what else can I do? I'm cooperating, my lord. Let them point out one single but I took one single date in the trial court. Nothing more than that. On every date of hearing, whenever cross was scheduled, my witness was there. Well, 20 minutes, 30 minutes, all of suddenly something would be said, a date would be given. 20, 30 minutes. When this court has made the matter time bound, they sought 3 dates of hearing for cross-examination. They come before this very court.
That order, I think, should have not passed, which should have not come percolated into all this.
No, my lord. My lord, they took 16 dates.
Intelligence that is shown by the court for your client is now.
My lord,
that's
would
how
recollect-
It has gone to the extent of making allegations against the judicial officer.
My lord has seen lot of judicial officer. I'm very sure of it, my lord. Like we also got lot of juniors working. Some of them, they commit some mistake, my lord. Let me point out. And now this is the greatest sign. On this Saturday, after 3 dates of continuous cross-examination, almost for 5 hours, they are done in last 3 dates of hearing. They made a statement in the trial court that they are going to close the cross-examination on this Saturday.
On both your applications, neither will enhance the maintenance nor will reduce the maintenance. Both your applications will be dismissed. Let the court decide whoever is now it's going to conclude. Let the court decide on the ultimately whether what is the maintenance that is entitled basing on the evidence. Now at this stage, on an interim application, again on a main application, how many times
Yes.
this exercise has to be done?
But my difficulty is that, my lord, this girl, she's very well employed. As per her admission, she's making 33 lakhs every year. She makes a false statement on oath before the trial court, not at one stance, my lord. I can take.
Ask the court to initiate.
Yes, my lord.
Both of you come up with, according to them, you have suppressed.
No, my lord, let them point out.
Let both of
Yeah,
you.
let them
And
point out
let the
anything.
Let the court take a serious view and will also
Yes,
point
my
out.
lord.
Court has to consider the scope of this petition where her wife draws an amount of 33 lakhs. Husband
Admitted.
draws a annual income of 4 crores or
No,
5
crores,
crores.
8 crores plus.
8 crores, 8 lakhs. ma'am.
8 crores.
Yes.
So what is this? Now, why the wife is coming up for the enhancement? Your income as of now is 35 lakhs.
33, around 33
33.
lakhs.
So per
Yes,
month, how much it is? It is almost 2.5 lakhs.
Please, ma'am.
And court has granted you 90,000 as maintenance. So it is coming up to how much?
My lords, my humble submission is that.
No,
my
it
lords,
comes to how much? It
Um,
comes to more than, it's
Around 3.5
almost,
lakhs, my lord.
almost 4 lakhs,
Please, my lords.
3.5, 4
Please,
lakhs.
please, my lords.
So there are no children out of the wedlock.
No, my lords.
Now, according to you, now, because my husband is earning 4 crores and 8 crores and odd, I should be granted.
My lords, my submission is that, my lords, the application has been filed in 2018, my lords. I started to earn the current amount which my lords have stated right now. It only in the year for 2022 onwards, 2022, 23 and onwards. Till that, I was not having much income, my lords. Even my ITR speaks what I was having. I did had my businesses.
Again, false
Because-
statement.
My lords,
Sorry, my lord.
let me make
They
this-
filed their evident assets and liability in this year, 2024. Therefore, this matter came to be decided. How can they disown? How can they say it is 2018, my lord? Very
But the affidavit has
reckless
been filed in
statement.
2022, my lords. Thereafter, after the direction of this honorable court to produce the assets and liability, because they never produced the assets and liability. This honorable court directed them. Because of that reason, the matter was pending till long in the trial court. There is a clear direction passed by this honorable court.
What are your expenditure? Why do you require 3 crores, 3 lakhs per month? What is the expenditure?
My lords,
Is
it
it
comes around.
because because the husband is earning 9 crores or 8 crores according to you?
My lords,
You should
that-
also have proportionate. But this is very unfortunate. Court is feeling, now these kind of petition, just for the sake of you have money, he has money, both of you come to the court.
Lords,
That is not the purport of interim application. What section 24 says?
please,
read
my
it.
lords.
Was not
My
able
lords,
to maintain.
Not
At
for
the
clients
point
like
of time
you.
filing of an application, my
Both for
lords.
your clients.
At the point of filing application, my lords, there was no income, my lords. Actually, my ITS says that I
That
was.
is done, that is
Please,
done
my
at
lords.
point of time. Now 2024.
Now I'm.
Where is enhancement now? Where is enhancement now? Now, in that case.
But the
you're
reason, my
only
lords,
entitled for-
the
no, no,
wife
then-
need to have
no,
the
no, no.
same status of
That
the husband, my
in
lords,
that
not.
case, you are entitled only till 2022. Because 2022 you are employed now.
Please, my lords.
And then
But-
the court shouldn't grant maintenance after 2022. When a person who is earning 35 lakhs, why do you want still maintenance from the husband?
My lords, my humble submission is that, my lords, what I'm earning for a year, my husband earns 66 lakhs per
I
month.
don't think that is the purport
Oh,
of.
my lords, no, that's not my intention, my lords. The reason is that, my lords,
Alimony or whatever you want to
My
ask
lords,
as. But not.
the wife has
because
to
he's
be,
earning that much.
my lords.
It is, no, you, out of the, I think he stayed for 6 months. That's what he was saying. on
That's
the
a wrong
last section.
statement, my lords.
See,
The rate of
April
separation is that, my lords,
2015.
1/7/2015, my lords. Marriage is, my lords, 26/2014. It's,
It is if they themselves claim on page number 462 as their expenses of 1,15,000 per month. It is her assets and liability. It is,
The order,
it is, sorry.
it
There
is
is a,
order in WP number 8612.
my lords,
my lord,
page number 492, my lords. The
in
operating
my
portion
petition,
at,
it is page number 22.
Page number,
22 in my petition, 622.
my lords,
petition.
4612, my lords, page number 492,
Four,
volume 2, my lords, volume 2. There are 2 volumes, my lords.
impugned order is-
492.
impugned order is in the second volume.
Please, my lords.
Yes, give that.
It is, I made a compilation of judgments of Supreme Court which says anybody who takes the court for granted, they should be.
Not anybody, that's what I made.
Yes,
it
ma'am,
very
let them
clear.
point at one single instance on my part, where I lied. There's nothing as such. I'm facing cross-examination on
All
data.
documents, where is the order?
Lords, 492, my lords.
How can you find an
492.
impugned order in the second volume?
Page number 492.
Give that second writ petition.
My lord, it is in page number 22 on my compilation,
Page number,
22.
that's the one.
It is a matter under
With
the,
the orders passed in.
there is a one more request, my lord. I'm relying upon the judgment of Supreme Court which categorically says anybody making the false statement, taking the court for a right, they should not be entertained. There are 3 direct judgments of the
Agreed
Supreme
with
Court,
the
my lord.
Orders passed in, take that, agreed with the orders passed in. Where is IA? What is this order, in which case?
My lord, this was for the interim maintenance.
Where do you get that?
My lord, the title itself.
The agreed with orders passed
Madam.
by the trial court under section 125 CRPC, under section 24 of the Hindu Marriage Act, in criminal miscellaneous number 635 of 2019, criminal miscellaneous number 293 of 2023, and MC number 6470/2022 dated 12th February 2024, both the wife, whereby the court had granted 90,000 as maintenance, both the husband and wife are before this court. The wife's writ petition is WP number A612 of 2024, and the husband's writ petition is WP number 6222 of 2024. The husband has filed MC seeking divorce. Before, while in the pending MC, parties have come before this court by filing several writ petitions. Initially, WP number 11146 of 2022 dated 31st January 2023 is filed. Agreed by the order passed by the family court dated 1/12/2021. Upon the application under section 91 of the Code of Criminal Procedure in the criminal C miscellaneous number 635 of 2019. The court had passed an order dated 31st January 2023. The stage for consideration of all the modified is in a challenge to an innocuous order would not be entertainable. Hence, leaving open all the contentions of the respective parties to be urged before the court. The petition is dismissed. And the court has also observed that both the husband and the wife shall cooperate with the proceedings for its conclusion in terms of the order. Then WP number 21986 of 2023 and WP number 26319 of 2023 are filed by the husband. In these writ petitions, both the wife and husband have preferred two writ petitions. Where husband questions the interim order of maintenance and the wife questions the maintenance and seeks enhancement, and the husband questions the order of granting maintenance. Then the court by order dated 19th January 2024 had remanded the matter back to the court to consider the application, bearing in mind the observations made in the order, and after perusing the assets of liabilities statement of both husband and the wife, and directed the trial court to terminate the proceedings within 6 months. As it is now 7 years that the parties are fighting before the concerned court. And the court has observed that on the application under section 24 of the Act, on a decision under section 24 of the Act, the proceedings shall conclude within 3 months. If the wife or the husband would not cooperate for conclusion of the proceedings, it is open to the concerned court to pass appropriate orders without waiting for the husband or the wife, whoever would default in not cooperating with the proceedings. And the wife is permitted to withdraw the amount in deposit, that is 15 lakhs, that is to be deposited before the court. Then another writ petition, WP number 6599 of 2024, came to be filed by the husband, wherein he had he has sought a relief, directing the family judge to appoint advocate commissioner for recording the evidence in MC number 6470 of 2022. Or alternatively, to direct the court to record evidence through video conference. And the same came to be disposed of on 12th March 2024, whereby this court has directed the trial court to give the dates for the cross-examination continuously as required by the learned counsel for 8 days. And in the next 8 sittings, the respondent shall conclude the cross-examination. The petitioner, the husband is at liberty to give the convenient dates in this month. Accordingly, the writ petition is disposed of. Thereafter, the trial court had passed this order whereby maintenance of an amount of rupees 90,000 is granted to the wife. The husband had leveled certain allegations against a judicial officer, and he has made a officer, and basing on that, the case is transferred to the other court where the cross-examination is going on. Now, both of them, the husband at one hand says that the matter has to be disposed of as expeditiously as possible. And now they have come up questioning the interim order that is passed by the court granting maintenance of 90,000. The undisputed facts are that the wife is earning an amount of rupees 35 lakhs per annum. According to the husband, his income per annum is 5 crores.
8 crores, 8 lakhs, my lords. But
According to you,
no, I'm not saying this is her income.
your income.
My income is more than 8 crores.
His income is more than 8 crores. The husband's stand for questioning the said order is, she had not stated all the relevant factors before the court. They stayed for a very short time. And he cannot be made to pay maintenance to her when she is able to maintain herself. And according to the counsel for the husband, she has come before the court with suppression of several material facts, and the perjury proceedings are supposed to be initiated against her. It is a submission of the counsel that no party shall be permitted to take the courts and the process for a right. And for a right, he submits that it is the case of the husband that has lived for a very short time, and as he is not liable to pay the maintenance, the court ought not to have granted maintenance of an amount of rupees 90,000. Next, according to him, the wife all through was working, and the said facts were suppressed. Next, it is the case of the wife that till 2022 she was not having job. From 2022, she had a job. And as husband is getting 8 crores of 8 crores per annum, she need to have maintenance of how much was claimed?
3.5 lakhs
3.5 lakhs
in 2017.
per month.
18.
Per month. Looking at the respective contentions of both the parties, they have taken, both of them have understood the purport of section 24 in a manner which is beneficial to both of them. Give the act family court.
It is, I got the printout of the Hindu, the section 24. Can I pass it on? Only I got the printout.
Section 24 of the Hindu Marriage Act deals with maintenance pending life and expenses of proceedings. Where in any proceedings under this act, it appears to the court that either the wife or the husband, as the case may be, has no independent income sufficient for her or his support and the necessary expenses of the proceedings. It may, on the application of the wife or the husband, order the respondent to pay the petitioner the expenses of the proceedings and monthly during the proceedings, such sum as having regard to the petitioner's own income and the income of the respondent, it may seem to the court to be reasonable. As the said provision deals with having regard to the petitioner's own income. Now, the wife comes up before the court saying that the husband's income is 8 crores per annum. She should have 3.5 crores, 3.5 lakhs per month. Any of the party, now when she comes up with an application, it's for her to prove that she is not able to maintain herself and she is in need of a maintenance to take care of the care of herself and the legal necessities. In this case, now when this order is passed on 12th February 2024, from December 2022, she is already earning an income of 35 lakhs per annum. And apart from that, now the court has granted 90,000. Now the wife again comes before this court seeking enhancement of the maintenance that is granted by the trial court. This is nothing but a pure abuse of the process and also exploiting the provision that is for the purpose of helping a party who is not able to take care of herself because of these disputes that arose between the parties. The Honorable Apex Court and this court also in several cases has considered that while granting maintenance, court has to look into the social status and how they were leading the life before the disputes have started. All those judgments cannot be applied to a case of this nature, where a lady who is a woman who is getting a salary of 35 lakhs per annum and a monthly maintenance of 90,000 is not sufficient to her. In fact, when this matter came up on the last occasion, this court has expressed that the court would dismiss these applications with the exemplary cause. However, taking a lenient view, this court is not imposing the cause, and this court feels that this is not the case where wife is entitled for enhancement of the maintenance, and accordingly, her appeal seeking enhancement is dismissed. Next, coming to the writ petition of the husband. Husband questions the order on the same grounds which were earlier urged by him, where he wanted a perjury proceedings to be initiated, where the court said that would be taken up at an appropriate time. In spite of that, with the same stand, one after the other, he is coming before the court. First, he wants the writ petition, my MC itself to be disposed of. For that, he says that he cannot, he resides in Bangalore, Mumbai, he cannot come to Bangalore. So some timeline should be prescribed for conducting the cross-examination, or else it should be done through video conferencing, or a commissioner shall be appointed. Now, when the schedule is given by the court, and when the interim maintenance is granted, and when the final application itself is going to be disposed of, he wants to again agitate and go back to the very same application, and his prayer for early disposal, cross-examination, and all remains to be the same. He has gone to the extent of writing letter against the judicial officer that the timeline she is not adhering, and several other allegations are made. Now the parties, in the light of their ego tussles, are going to any extent, and except their egos, they are least bothered about any other issues. A simple logic where he wants an early disposal when the ultimate maintenance will be decided by the trial court. It is not his case that he is not in a position to pay 90,000 rupees. If on evidence placed before the court, if the court comes that the wife had approached the court with all suppression and misrepresentation of facts, and the perjury proceedings have to be initiated by either against any of the parties who have come before the court with all misrepresentation and suppression of facts, the orders would be passed, but the husband do not have that patience, and the same grounds, as if deciding the main MC itself, everything has to be decided by this court. Now, whether she has suppressed the facts, whether she was working or not, all these things will come during the course of trial. For that, this court at this point of time is not inclined to interfere with the order passed by the court. Next part, accordingly, there are no merits in the repetition of the husband as well. Next, in view of the above discussion, this court is passing the following order. On if any applications are filed by both the parties with regard to the making any false submissions or about an allegation of perjury, the trial court, while deciding the main application, shall also decide these applications, and shall take a seat that is on the perjury criminal side. And at the same time, if the court finds that there is any of the parties have played with the process of the court, exemplary costs shall be imposed on both the parties by the trial court. Accordingly,
The court had indicated that because the matter would be over in hardly 2 months' time. During that time, this money, let everything be decided at once. If the court says finally that I'm supposed to pay the money, I'll pay at once. Because the difficulty is that now they will move the.
Till the matter is disposed of, the money that is awarded by the court shall be deposited in the suit account, before the trial court.
In the nature
And
of it.
once, once the court feels that the wife is entitled for maintenance, then the entire amount at 90,000, the entire amount till now shall be deposited by the husband before the trial court.
My lord,
Yes.
one correction, my lord, it's not 30, 35, 33, my lord. And another one contention, my contention is only the court has decided upon the strength of the salary slip that may be added.
What is that?
Salary slip of 8 lakh rupees, what they have given, on that 90,000 rupees has been awarded, not with respect to income tax of 8 crores. It's our major ground. Major ground. That ground may be added.
Whether the entitlement of the wife with regard to maintenance shall be decided in the main application itself.
Much. And the application perjury.
At the docket order, as per the order of this court, the registrar judicial has placed before the court the report of the family court, Bangalore.
And further, my lord, 340 application was filed much before, my lord, which is pending. We requested, but as of this was there, it was kept like that itself.
Both your applications will be decided.
There is just one request. Should I deposit in the nature of the FD? Because should I deposit the money in the nature of fixed deposit, ladies? Because that will get some little extra.
Before
Before the trial. Yes, I'll do. I'll do.
A timeline may be fixed.
It's all.
Own timeline, already too much of indulgence for both of
No,
you.
my lord.
But I
Depositing
know
of-
this pass, you should feel happy.
Much of place, my lord.
Yes,
It's
Cell
not.
number 25,
yes.
Krishnamurthy TR, N Vasant Kumar.
Preparing for respondent. We had filed IA number 1 of 2024 for release of amount deposited by the petitioner. That is worth amount 60,000 rupees. That has
These are the amounts filed.
The respondent.
respondent.
IA number 1 of 24 is allowed and the respondent is permitted to withdraw the amount. Suppose it's
And
not-
with regard to main petition, my lords, we have already stated in the objection that
We
it
will
may be
hear it,
allowed
We'll hear it later. First, we'll decide the.
late.
Suppose it's matter on 9th September.
Interim order can.
Interim order earlier granted is extended till then. Next.
Much obliged.
Cell number 26 for orders.
2 weeks time to
Alright,
remove
fine.
office objections.
Maintainability.
Maintainability is what happened is, my lord. I challenged the application under 39 rule 1 and 2, inadvertently filed some different order. Because all the orders are passed on the same date. While stitching it, by mistake, I filed some other order. I will rectify while complying with the office
For
of.
complying the office objection.
2 weeks time may be granted.
Why a week's time is granted?
Please,
If the objections are not, heard, same default order.
Cell number
Yeah.
27, State Vikas Rao, 27,
Valent in this case, my lord.
What is that? What is the statement?
My first submission, my lord, regarding the cost title, I have mentioned my permanent office address, Chennai. My lordship, in the year 2013, we entered the joint development agreement in Bangalore between the appellant and respondent number 1 and 2. And
Please come to the cost title before the trial court.
before the trial court, Your
There
Honor,
is the order, impugned order.
no order, Your Honor, I have challenged this, in the plaint, page number 32, my lord.
No, what is impugned in this writ petition?
Order 39 rule 1 and 2, not, is
Please come to that page number 20.
page number 20, Your Honor,
Yes.
my lordship.
Yes. You are for the defendant.
I am
You
for
have
the,
contested the matter.
yes, Your Honor, I am
Find the
only,
written statement.
yes, Your Honor, I have,
Where is your written statement?
my written statement, page number, my lord. Uh, Page number 43, my lord. Annexure C.
What did you say about your address and all?
Address, my lord, in the 2017, all the
Written statement.
written statement have not stated in the address, Your Honor.
Then now suddenly before this to court, how the
Uh,
cost title can be changed
My
now?
lordship, page number 58, I have produced the general power of attorney.
Hmm. Yes.
I mentioned the Chennai address, he is the permanent office, my lord.
No, whatever the cost title is, it will go as per the order. How
No,
can it be changed now?
No, my lord, in the year 2019, the respondent number 1 and 2 is filed suit for partition. 2017, the all, as per the contract, I have done my work. Temporarily, I have the function, the office in the Malleshwaram. In the plaint awareness, the purposefully mentioned the Malleshwaram.
Why did you not say so in the written statement?
Yes, Your Honor, my written statement,
No, let it continue, whatever it is, you can ask you can tell the court below, not now. Next, what is the objection? That you have to
other
comply with.
objection, my lordship,
Yes. Well, let us see what are the objections.
dispensation of the notice. I am
First,
seeking only
1
relief.
minute. I have filed with infiling the address also. First,
Seal and signature, it is the independent person signed the the proprietary concerned execute the general power of attorney. I have
First
produ-
of all, address of appellant to be stated correctly, that you have to
seal, my lord.
next
Second
to-
one, seal.
seal of the firm to
The-
be affixed in wakalat.
No, my lord, his signatory is in the GPA holder. I have produced the GPA. The proprietary concerned execute the GPA. I have produced page number 58. He's an individual person, my lord. Now he is represent on behalf of GPA holder.
Who is the party?
Party is the proprietary.
Respondent is Mrs. Evergreen
Yes, Your
Properties
Honor.
and Investments, so and so represented by its proprietor.
Now, my lord, as per the GPA, page number 58, he represent on behalf of the GPA holder. He is the individual person.
Next,
Next to my lord, same schedule. The C schedule, whatever the dispute in apartment number 405 is the only dispute. But the plaintiff is mentioned entire the property, B schedule
Then
property.
change all that here. What is this?
No, my lord.
You can't, this is not, we are not running a trial here. Whatever is it that you have to mention here. Is it not?
Yes, ma'am.
That also comply with that objection.
And another last, your my lordship, dispense the notice, other respondents, 3 to
Go
14.
to respondent number 3 to 14, we have dispensed with, since relief is against the respondent only.
And kindly issue notice to the 1 and 2.
Where is this? You have
Condo-
filed a memo.
Yes, your, I filed memo, my colleague is filed memo.
You can write that. Yes, please come. The office has raised certain objections. The objection number 1, the petition has to comply with. Objection number 2, the office objections are overruled. Objection 3 and objection 3, that is documents to be furnished. 3 has to be complied with. And note to respondent number 3 to 14. Is sought, the notice may be dispensed with, since they have sought the, no relief is sought against them, and it is only against 1 and 2. At the risk of appellant, notice to respondents 3 to 14 is dispensed with.
And also permit to serve the copies to the trial court counsel, my lordship.
The, first of all, that it has to come up for hearing,
Will
court has
answer.
to hear, then the court will just post this matter for, after the complying with the objection, post the matter for preliminary hearing, for admission, yes. Next 28,
28, this, 29, dispose, seal number 30. Mohan Adekar,
post after service of notice, yes, 31.
number 31.
Petitioner, ಇದರಲ್ಲಿ the petition itself is not maintainable. Kindly peruse blood order annexure.
Give that.
This
What is
the
the order?
respondent
Give-
filed application under order 7 rule, rule 11 D malad for not rejection of plaint. That application came to be dismissed. So malad he has to file CRP, not writ petition. Writ petition is not maintained.
The petition under,
Your
come
Lordship,
again, what is that?
This application, the application filed by the petitioner before the trial court, malad is a defendant, malad for rejection of plaint. Under
That is
order,
dismissed.
that application rejected or dismissed. So malad against that order, malad CRP is maintainable, not writ petition.
Why?
Because malad this all court, malad
227,
227 not maintainable. Only CRP section 115 is maintainable.
how can it be?
This is the reason, malad.
Give the
This all court allows this application. The my suit will be dismissed. That is the reason that CRP is maintained.
No, that's, no.
Kindly peruse 115.
Yes, yes. No, your suit. Now the suit is pending before the trial court.
Suit is pending before the trial court. He has the respondent.
So what is the distinction between 227 and 115?
115, my lord, that is sorry, 11 in section 115. But I am unable
Give
to-
him, Anita. Give him CPC. Give him.
Suppose the San court allows my his application, blood, my suit will be disposed of. That is the reason, blood, section the say 115 says, revision, the High Court in case arise out of original suit or other proceedings of the value exceeding 1 lakh rupees, and the district court in any other case, including a case arising out of original suit or other proceeding instituted before the commencement of the Code of Civil Procedure, may call for record of any case which has been decided by any court subordinate to the High Court or the district court, as the case may be, in which no appeal lies thereto, if such subordinate court appears to have exercised jurisdiction not vested in it by law, to have failed to exercise jurisdiction so vested, to have acted in the exercise of jurisdiction illegally or without material irregularity, had the High Court or the district court, as the case may be, make a such order in the case of as it thinks fit.
227 petitions are entertained.
Not maintainable, there is a reason.
Please tell-
Provided that,
Please place the judgment, we will see.
that I will,
Your lordship,
Suppose this matter after
your
tomorrow.
lordship, all to kindly accept, respondent number 2, the child, your lordship. Child.
Learn counsel for the respondent. Shall
Respondent
take
number 2 is
notice on-
child, no?
Respondent number 1 shall take notice on behalf of respondent number 2 also. Yes, 32. Child. Yes. Yes, 32.
32. Cell number 32, Nataraja. Non-compliant
No
summons.
representation for the petitioner. Hold this matter on 10th of September. Yes, 33.
33,
Post after service of notice.
34.
Oblations.
Cell number 34,
No
Pana,
representation.
yes.
No representation.
My lordship, I am the respondent herein, and I'm yet stuck. The trains to Bangalore have been cancelled off again. Since there is no representation from the opposite side, if matter can be posted on after the 25th of September, I have another matter in Bangalore for which I would be coming before the
I
High
think
Court.
already, if I remember, you have asked for time on the last occasion.
Last occasion.
Yes, my lordship, I'm coming all the way from Bombay. So my
That's
trains.
not the problem. Every time matters can't be adjourned on that ground. How can?
No, my lordship, I'm ready to argue if my lordship is ready to hear the opponent, the appellant is not
No
before this court.
representation for the petitioner. Pose this matter tomorrow. Yes. Next.
Cell number.
Much
for
obliged,
August
ma'am.
Matter at 4:15, cell number 39. Chandranatha Gaule.
I appear for appellant, my lords. The name of the appellant was wrongly mentioned in the lower court, my lords. We have enclosed the Aadhaar card, my lords. Your lordship find it in page number 77 of the appeal memorandum. His name is actually H.D. Devegowda, my lords.
What is the difference?
So, in the cost title, it is reflecting as H.D. Devegowda. His name is wrongly mentioned in the lower court as a Dyavegowda, but his name actually is H.D.
That
Devegowda.
rectifications and all can be done before the trial court, not here, not required.
My lords, with respect to the LRs of the petitioner number 1, the appellants herein, itself, they are the sons of the appellant.
That we will take it.
Please, my lords.
Where is the memo? To that effect.
My lords, we will file application.
You, this is a MFA, not a writ petition that wherever, whatever you say can be.
Yes, we
Learn
will file
counsel
our
for the applicant submitter, they'll come up with an appropriate application, they'll come up with a memo. Delete from orders at 4:15 PM. Let it come in a usual course, yes.
Cell number 40. Submissions of type copy of Annexure C and J.
Delete
Delete from.
for orders at 4:15. Post this matter on no representation for the petitioner, post on 10 September. Yes, next.
41. 41, Puneet K. Kariyanna. Counsel submission.
Appearing for appellant in this case, my lord. My lord, I pray for 4 weeks adjournment, my lordship. Yakendre, the out of the court settlement is going on, my lordship. So therefore, I pray for 4 weeks adjournment.
Counsel submission with regard to the office objections. Now that you have to submit.
My lord, the office has raised 2 objections. One is regarding the IA, the challenging IA. My lord, in page number 15, annexure A, which is the first page of the order sheet,
Give that.
invoice number 4091 of 2023. At the end, my lord. At the end, it is written as IA number 1 of 2023 is section 80+2 of CPC. And IA number 2 is 39 rule 1 and 2, my lord. In the order sheet, it is wrongly mentioned as IA number 2 was withdrawn. The IA number 1 was withdrawn, my lordship, and IA number 2, the orders was passed on IA number 2, my lord.
So what is to be done now?
My lord, it is to be considered
Something is wrong. Who has to correct it?
at the trial court, my lord.
And then you should seek for a right application from there and then come back. The objection shall be complied within 15 days.
Seal number 42.
For
Or
appellant,
this-
my
The
lord.
appeal shall stand dismissed.
In this case, appellant has to pay the court fee, my lord. 2 weeks time may be granted, my lord.
So for complying with office objections, finally, 2 weeks time is granted. Same default order. Yes, 43.
Seal number 43.
The office objection is with regard to the maintainability. That by virtue of the stay order granted by this court, that it is maintainable. That is my submission.
Office has raised objections with regard to the maintainability of the appeal passed by the senior civil judge at Mangalore. Since value of the COT is below 10 lakhs in view of section 19(1) of the Karnataka Civil Codes Act, then counsel appearing for the petitioner, for the appellant submits that in view of the stay orders granted by this court and a writ petition, the appeal is maintainable before this court and also a circular issued by the registry.
Please.
Yes. Office objections, the overrule, pose this matter for admission.
Admit, come for admission.
Yes.
Please.
Seal number 44. Kumar.
For appellant, my lord. 2 weeks may be.
Right,
Yes, madam. I am for appellant. For appellant, 2 weeks may be granted.
23 MFA.
Yes,
Why do
ma'am.
you want 2 weeks for complaint?
There is a.
Post after a week.
You need to
will-
file-
No, not post after a week, within 1 week. The office objections have to be complied with or else same default order.
Need to file.
Give the dictation.
Seal number 14.
That's one submission. So far as seal number 24 is concerned, my lord,
24.
it was passed over.
Uh-huh.
23, my lords.
Huh.
If your lordships could have it on another day, my lords. On Monday.
Where is the other side?
My lord, I appear for the
He was asking
correspondent.
time, she was insisting for this.
My lords,
to-
because I had moved the memo, my lords.
What is urgency in this?
My lords, visitation rights, my lords. I'm for the husband.
What is the matter?
The trial court has given me only every 15 days, a 1 hour time on a Saturday or a
What is the
Sunday.
age of the boy or
My
girl?
lord, there are 2 boys, each of them are about 7 and 10 years old approximately. Being the father,
Where do you stay?
my lords, at the present moment, I stay in Netherlands. I'm only seeking for a weekly visitation rights and
You
50%
stay in,
Netherlands, Amsterdam.
then where is the wife?
I have only moved to Netherlands last year, my lords. That was much, that is much before the interim order, the impugned order was passed. Pursuant to which I have moved to Netherlands for my work purposes. Only thing that I'm seeking at the hands of your lordships is for visitation rights insofar as weekly video calls are concerned on a Saturday and Sunday for a period of 1 hour, as well as 50% of the summer vacations or vacations to that effect.
Was it sought before the trial court?
It was sought before the trial court. Trial court has granted a different.
Pending this application, let that, because anyhow he's
Let
not
the-
in India.
I'll take about 5 minutes, my lords.
Oh.
The background of the situation is this. From the birth, the father has had very little to no bonding with the children. They're actually twin boys. They're not 7 and 10. They're twin
Sorry,
boys.
My apologies. The twin
They're
boys.
Twin boys. When the matter was, when the application was filed in 2022, great urgency was shown that around September or thereabout, saying, I'm going off to Netherlands permanently in about October. I need immediate access to the children during the Dasera vacation. But for a period of nearly 1.5 years, there was absolutely no movement, no intimation sent. There is further background history as well, where the father has behaved violently with the mother. Children are witness to it, unfortunately. He has smashed the TV in front of them. Owing to all these violent events, the father was requested, please leave, let there be a cooling off period. And then COVID set in. There was absolutely little to no contact. He showed no interest in taking.
COVID was in
Allah-
2020 and
No,
we
no,
are in
let-
2024.
My request, let me finish my submissions. He can rebut. There was little to no contact with the father, even though he would, in fact, even before the filing of the application, I had absolutely no issue with him coming or making visitations to the children or calling them. One thing that took place was he would insist on video calls out. This is all part of pleadings. The children have made statements to this effect as well. He would make video calls. He would ask them interrogative questions, take the phone around the house. What is this? Who bought this? When did this come? It was more of troubling the children. And then this other violent incident took place, after which there was a restriction on him meeting the children. Then once this application came about showing great urgency, even after the filing of application, for about four to 6 times, though the court granted an order, though he was in Bangalore, he never made any efforts to come and visit the children. Now the issue is this, the twin boys, one of them is mature for his age. He understands his mother is going through court proceedings, divorce and all that. Because she has explained to him there's a court order, please go and talk to the father, obey the court order. From her end, as a mother, she is encouraging the child to meet. The other twin boy, he's a little playful. He doesn't want to be in that uncomfortable space with the father. He goes away. So on certain occasions when the visitation order was being obeyed, he has made the child to sit on the lap, secretly recorded him having a conversation, or he has forced the child to smile and saying, this is for your grandmother. You please post photos so that he can use it as evidence in court or whatever it may be. This the child has noticed and later on told that father was secretly filming me, again putting the child in an uncomfortable situation. Then there was yet another incident. Where he,
kindly note,
let me finish. Let me finish. All these are the incidents that have taken place. All these incidents have taken place. The child can come and interact with my lodge directly. It was holy and it was his day of scheduled visitation. The child has played and it didn't want to go and meet the father, the twin boys. One of them went and the other didn't want to go. So the mother said, go, please go. There's a court order. You have to meet at these times. He later on, the mother has sent they stay in an apartment community. The boys have gone. One of them has felt very terribly uncomfortable. He has come back and he has cried inconsolable, saying, mother, why did you sort of abandon me with dad? I didn't want to talk to him. And then next day he fell ill. He got fever and he didn't go to school. So the situation is such that it's very uncomfortable for them to interact with the father. It's not that the mother is poisoning their minds or anything. The mother is more than happy. She's encouraging, in fact. I am reiterating that even before the application was filed, the mother was being cooperative. And there have been numerous occasions where, despite...
Let her continue to be. Let's see.
No.
We can't
My lord, let me
abandon
finish.
the-
No, let me finish. Kindly hear me for 3-4 minutes, my lords.
You said 5 minutes are already over.
My lord, I'll try to speak faster.
Yes.
Since the hearing has commenced. So there have been incidents where the father has said, you know what, I'll buy you a new car. And then he's sort of tried to dangle in front of them that I'm moving abroad, I'll take you abroad to Netherlands, you'll have a more comfortable life. And then he says on video calls, he's trying to influence the children basically. But the children are clear that I don't want to do this or not.
No.
And then
No, I understand, because with all the cases hearing day in and out, I can understand what is your submission there. Please find out from your client, it has to happen, how it has to happen, what are the restrictions that are supposed to be, and which makes the children comfortable. Let her tell the court.
The difficulties are threefold currently with the order. Now, before that one submission, I had pleaded in my statement of objections. I had asked the trial court judge, kindly interact with the children. I made the submission when the matter had come up previously for hearing. This honorable court was pleased to direct the trial court judge interact with the children independently, one after the other, and submit a confidential report. In fact, that report is there. It was read by the, in that report, they have.
Just accept what all you're saying is correct. Let's say what all you're submitting is correct and that's what is happening. So from there, what is to be done is the next.
So currently the issue, practical difficulties are this. There is one order of video call on Saturday and Sunday. That, second and fourth Saturday of every month, that he is not adhering to. Every time the children are waiting, the mother is waiting, cancelling all their appointments, whether the father will call or not. The mother is a working mother. She has got 2 aged parents in the same community. She runs the household. She comes back, cooks for the children, takes care of her studies. They have their own independent schedule, maybe a birthday party, the cricket camp. They have their own travel, vacation, school camp, whatever. Everything she's doing single-handedly. So even for those 2 days where if she wants to take time off, she's not able to because she has to abide by the court. What direction is there?
What
Now,
is the time?
about 4 p.m. to 5 p.m.
Then we will
Three-
extend it little later.
No,
So
so,
that,
so I'm say my request is this currently
3 to 4
pending,
minutes.
pending disposal, or it may be modified to say, if he is in Netherlands, kindly let him intimate on Wednesday that he will have a call on Saturday and send a Zoom link. Because every time for the past 1.5 years since the order has been enforced, in fact, when the order first came out, there was a long pending vacation for the children. I had to cancel it and the children could not go and they were terribly disappointed about it. At his whims and fancies, whether, and also when he was in India for a period of 1.5 years, it is at his whims and fancies whether he chooses to visit or not. There have been many occasions when he has come up on a Friday or on a Sunday without telling, and then he says, I want to see the children.
So basically
So-
he's saying,
so let
I
him
have to
give-
seek an appointment to meet my own children.
So let him give,
so,
That is what it is come down to.
no, but that's how, that's exactly what it is now.
and
Because it's
Precisely, my lord,
investigation.
kindly look at the conduct of the respondent wife,
Citizen.
how
No, you're-
bitter or how manipulative she can
my lord,
be
she has been
to
encouraging
the
and she's
children
ready to
against
encourage even now
petitioner father.
also. She's not coming in the way, my lords. All I'm saying is,
What is wrong in what he said?
let him give a prior because it will show, my lord, he has gone
My
back.
lord, I have no problem in giving an intimation,
Give
but the
them-
problem is the enforcement of which is not taking
See, that's
place.
why this weekend, when are you going to call them, give them the
I
intimation?
will give an email to that effect. Let them adhere to that. Let the children come on a video call. I have no
My lord, let it
restriction.
be on Saturdays, second and fourth Saturday.
Let the submissions be recorded. I can place a certified copy before I can produce a certified copy to the petitioner. He will do the needful. He'll send an email to that effect.
My lord, for July, he had
So
come.
let that be pending disposal of the present,
Understand?
my lords.
No, whenever there is a visit or a video call and all, no, everybody will have their own work to do and she has to go out or whatever. She's a working mother and they all wait for you and you ultimately don't call them.
My
What
lords,
will
that has
happen?
never happened. The problem is, this is a
See,
bitter,
what we will do
this is a
is,
bitter
what we will-
wife
Please
that is
listen to the
taking out
court.
a vengeance
We
through
will
the
have
children.
this matter after 15 days.
Please, my lords.
On this Saturday, first of all, by Wednesday, indicating the time and other things, let your client send a mail to her.
Please.
Let him adhere to that. And
In an event that is not complied by the respondent wife, I will permit me to move a memo on Monday morning, my lords.
no, we'll give one more week, then you can, that it will come up automatically before the court.
My
Please
lord,
go.
anyway, this 24th is a scheduled call for them. In fact, my lord, she has gone back. May I submit, my lords?
24th.
24th is a fourth Saturday. As per the order, he has to comply. He has gone back on somewhere end of July. It is whole of almost
He's
August.
booked out last year, my
August,
lords.
August is over. He's not even bothered
24th
about the children.
It is submitted that this 24th, the father is having the scheduled video conference with the children to talk to the children through video call. It is a submission of the land council appearing for the wife that many a times they are waiting for the call and the father is not available, which is denied by the land council for the petitioner
Husband.
father. This court finds force in the argument of the land council for the wife. Now, if it is scheduled on 24th, by Wednesday, the father shall confirm that he'll be calling them through video call at that, what are the timings?
My lord,
3
the
to
order
4
says 7
minutes.
PM to 7:30 PM as per para 3 of the order, page
That is
26.
Between 7 and,
7
My
to
lords,
7:30.
My lords, one submission. Second and fourth Saturday is my visitation rights, physical visitation. Insofar as
They're
video
not
calls
there.
are concerned, it is on every Saturday between 7 to 7:30. Because I am
7
on,
to 7:30.
please,
No, we are not.
kindly
doing
permit me to have it between 7 to 8 for a period of 1 hour. That's all I'm asking for.
My lord, I would be.
Because I'm staying in Netherlands and I've not had any interaction for the,
Let it happen for 2 weeks, then the court will see what
Please,
is happening.
please.
Between 7 and 7:30. Again, on 31st of, again on 31st of August, by 28th, he shall confirm, he shall send a mail to the wife. And again on that day, between 7 and 7:30, he can have the video call. Pose this matter on 2nd of September. Basing on what has transpired, the court will pass a further order. Yes.
cell number 40.
Please, grateful minutes.
Judgment.
Lordship's guide permission. Kindly see the para 8 of the plaintiff at page 140. Para 8 and 9. Only within 2 minutes I will complete. Page 141.
140.
Please. That thereafter, Lordship got it, madam.
Yes.
Para 8.
145 minutes, page number 145 of the court record.
Para number 7.
Para 8. That thereafter the plaintiff approached the BIPA authorities as to why any action has not been taken against the seventh defendant for not developing the A schedule property as per BIPA. But the plaintiffs were further shocked to know that the A schedule property was neither converted for residential purpose nor any layout plan approved by the BIPA in respect of the same at any time. The plaintiff on inquiry came to know that the seventh defendant has superimposed A schedule property in the plan approved in respect of survey number 68 and 79 of Misgaland village and misrepresented the plaintiff that in respect of A schedule property, also plan has been approved, likewise the seventh defendant has misled. The next paragraph, that the plaintiff then met the defendant number 7 on 31/7/2013 and demanded him to restore the developments made in A schedule property and also boundary stones to identify the sites formed in A schedule property. But the seventh defendant was adamant and he told the plaintiffs that the A schedule property in agricultural land and he will sell it as an agricultural land to the other persons. Lordship kindly see all the things is done by seventh defendant only. I have no concern with this. Then your Lordship kindly see one more thing. During the pendency of the suit, they came forward for compromise. Then immediately your Lordship, they have received 1 lakh each by way of this phone pay. Then after the defendants brought DDs for 50 lakhs, they have refused to receive the same. Now there is a settlement going on.
One is like this court is going to allow the appeal. If there is any settlement.
Yes, your Lordship can say already.
You can explore.
My lords, there's no possibility of settlement because what they have done is this, my lords.
Your Lordship
When there was an interim order, my lords, before when first suit was presented, they made an effort for settlement, my lords. When my lords claim was returned, when matter was going on before my lords, and they, my lords, took adjournment for 5 times. They did not. When the interim order gone, my lords, the trial court refused to grant interim order. Then they never turned up, my lord. We have no confidence in them
DDs
to,
are
my lords, for
ready.
any settlement.
Your Lordship,
Understand.
please.
That is not the situation here. That's not the situation here.
Please, ma'am.
Now the court is saying that if they do not come forward, they are at risk.
Correct.
So they will do it. Then we will pose this matter on Wednesday, Thursday, or which day you want. Because anyway, settlement is always the best mode of.
Because of that reason I told him, because
Solution.
even that
My
exists.
lords, my lords, I'm acceptable this. My lords, my lords, point 2 more things. Apart from my lords, settlement aspect, my lord, I'll
On the
come.
merits of it, you don't have to tell anything. Now
Yes.
I have a clarity on that. So for exploring the settlement possibilities of settlement, when can the matter?
Day after tomorrow, my lord,
27 or 28, my lord.
21st, my lords.
21st.
21st.
Day after
so-
tomorrow,
Allah, you are thirsty.
19.
2
Day
days
after
will
tomorrow.
agola. 2 days will
They have to give me a proposal. That's it, my lord. There's
26th, I
nothing.
think, holiday.
We'll take a decision
27th
one
or
day, 2
28th.
days. Because their activities, my lords, it's my lords quite affrighting me. My
It is
lords.
going on.
The 1 week doesn't matter. So
27th,
when are you going to come up with when are you going to give the proposal to him?
27th, my lord.
Pose this matter on 20, not 27.
Even let them give also a proposal.
28. In the meantime, whatever is the proposal, the both of
Please,
them
ma'am.
have to exchange. And by the next date of hearing, if no settlement is arrived at, court will pass orders on the merits of it, as the court had extensively heard the learned senior counsel as well as the counsel for that.
Please.
And also, my lords, my request, till such time, let them, they hold on their any activities. my lords.
No activity
Please,
is
ma'am.
going on.
Yes, sir.
Asking what
Let them
happened.
hold on.
It is submitted by the council on record. On instructions, learned senior
Development
counsel
activities are
submits that. Till such time, no further activity will be taken up.
Highly obliged. Highly
The
obliged.
further activity means, my lord, it has to be explained because several persons have purchased.
There will be status quo on all aspects as on today.
Your lordship again.
Highly obliged. Let that be
several-
words, my lords, are referred
My
to.
submission.
Till such time.
Several persons have already purchased. And they have taken the loan from the bank, they are putting construction.
152 sites they formed, my lords,
Yes.
superseding it, and they may not
No.
attempt. My learned
Aram-
friend is arguing for the
Aram the site.
purchaser, my lords, rather the landowner.
Not by your vendor, the subsequent
Now in this
purchase.
case, now in this case, if your clients, client in the sense that defendants, his actions are bona fide.
The purchaser, if the purchaser construct the building.
No, here the purchaser is before the court, it's a different aspect.
Correct.
But here it is
We
not the
are,
purchaser.
these defendants are not taking any action, then I will give undertaking. But the other purchasers will have constructed
By
now.
virtue of that is what.
Here the lordship will say, other purchasers have
Placing
constructed
in
one.
such a way.
We'll have it, no, what is supposed to happen might have happened by this time.
Yes.
Once we, no, last. portion.
Let there be that order, my lords, because my lords, it somehow protects my
We'll
lords.
have it on
Otherwise
28th.
what happens
Post
is
smarter,
Sir,
post smarter on 28th.
for further here
Not further hearing,
to report.
only to report. On the
pardon?
day we'll pass orders, no
you
hearing.
did, my lord.
Huh? 28.
Please,
My lords, it may part heard, my lords. It may not.
Part,
Highly obliged.
post as part, post not parted, post for judgment.
judgment.
Highly obliged.
Cell number, final hearing, cell number 35.
I'm ready, Manoj. 30?
Five. Final hearing, cell number 35.
My lordship, this is a wife's petition, my lordship. I'm advocate for a petitioner, my lordship. Where is the respondent?
Manjunath BS.
Another connected appeal is also there. Yes, my lordship, it is filed by the husband. There is no maintenance is awarded.
Representation for the respondent, also for the petitioner is present. Pose this matter on 3rd of September.
My lordship, kindly be on 27th, my lordship.
27th, it's not possible, 28th. Yes,
36.
36.
PD Raviraj, HG Swami,
Same, this no representation on both sides, September 17th.
7. Cell number 37.
37 on 24th of September, no representation on both, on behalf of both the parties.
Cell number 38, Chittappa,
I am for the petition in this
DP
matter.
Prasanna,
Where is the counsel for the respondent?
DP Prasanna,
Even on the last occasion also, my lord, he was not there.
Heard the learned counsel for the petitioner. Pose this matter as part heard on 29th.
With kind permission, Lord, serial number 40, Lord. I was under impression that I am seeking for a 2 weeks time, Lord, that with regard to that, I completed the maximum objection.
It's already adjourned.
it's on 10-9.
Time is granted.
Much.
Madam,
Court of-
Madam, 45.
ಇಲ್ಲ ಇಲ್ಲ 39. ಇಲ್ಲ 39 no ma'am, there is 27. ಇಲ್ಲ
ತುಂಬಾ ಲೇಟ್ ಆಗುತ್ತೆ ಅಂದ್ರೆ 28 ಅಂದ್ರು.
23/9.
ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಿ.
ಆಯ್ತು ಚೆಕ್ ಮಾಡಿ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಅಲ್ಲಿ.
Court officer.
ನನಗಿಂತ ನಿಮ್ಗೆ ಅಲ್ಲಿ ಕೇಳಿಸುತ್ತಾ ಹಾರ್ಡ್
ಅದೇ purpose ಬೆಳಗ್ಗೆಯಿಂದ ಕಾದಿದ್ದೀವಿ.
ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ನನಗೆ ಹೇಳಿಲ್ಲ ಮೇಡಮ್,
28 ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ನನಗೆ ಹೇಳಿ